Hello everyone, this video is about Arbitration and Conciliation Act 1996. This is mainly relevant for CA final students who are studying Set C in self-paced online modules, and other law students can also see this video to know about Arbitration Act. And if you want to learn about Arbitration Act, stay with us and you will be learning a lot by the end of this video. So, Arbitration and Conciliation Act 1996. First we are going to see about fundamentals of arbitration. Now, you will all have a question. What is arbitration? Generally, if we have a problem, where we will go? We have a dispute and we will go to court and we will file a case. But what is the disadvantage? What is the problem in going to court? If you go to court, it will take a lot of time. 6 to 7 years will take to complete the case, and it will be expensive. Lawyers are very expensive. And then we need a quick solution. So court is not proper for us. So we have an alternative method. Primarily we go through court, but when we want to have a quicker solution, there is an alternative. This is the topic for today, alternative dispute resolution. Under alternative dispute resolution, there are various methods for solving quickly the cases. Mediation, arbitration, conciliation, negotiation. Now, under these four things, we are going to see arbitration today. Now, this is called arbitration. Now, let us see with the help of an example, what is arbitration. Okay, let us look at the example. For example, there are two friends, Ram and Krishna. They together wanted to start a cafe business. They both are the partners. They are doing it as a partnership organization. This is the cafe. They are the partners. Now they have started the business. Now, after some time, they get a disagreement relating to profit sharing. Now, for example, 100 rupees is coming as a revenue, and after reducing the expenses, you have 70 rupees. Now, in which ratio they should divide it between them? Either they should divide it in 1:1, or one person should have more. Should they divide it in 60-40? Like that, they are getting a lot of problems. Now, for solving this problem, they are exploring the options. In what ways we can solve this dispute? Now, they have two options in front of them. The first one is court, and the second one is arbitration. What is the problem in going to court? In court, it is a very slow process. It will take years to solve the dispute, and it is very costly. We have to hire lawyers and we have to pay them. It is costly, and it is a public process. The judgment will be uploaded on the court's website, and anyone can view them, so it will not be confidential, and the thing can be viewed by anyone. Now, in arbitration, there are advantages for this. It is a very quick process. We are going to appoint arbitrator. He will decide the case quickly. It will not take years to complete the case. And it is cheaper. Instead of paying two lawyers separately, they can appoint an arbitrator and pay a fees to the arbitrator alone. It will be cheaper. And it will be private. Only the three persons will know about this problem. The party 1, party 2 and the arbitrator. No outsider can learn about this problem. Now, these are the advantages of arbitration, and this is the disadvantage of court. Now you can know which side is advantageous and you can select accordingly. Now, after selecting arbitration, both of them, they have to appoint an arbitrator. Before that, they have to agree to submit the issue to arbitration. For that, they have to prepare a document, and then in writing, they have to write that we are agreeing to solve this dispute through arbitration, and both of them should sign the agreement. This is the arbitration agreement. Arbitration agreement can only be in writing. So, this is an arbitration agreement. Now they are appointing an arbitrator, and the arbitrator will hear both sides without partiality. He should be independent and impartial, and he will make a decision. And after the decision is binding on both the parties. After the arbitrator has taken a decision, the parties cannot go back and say, I will not follow this decision. The decision is binding, meaning that both the parties should compulsorily follow whatever the decision is arbitrator is taking. So this is a binding decision. This is about arbitration. Now, we have learned some key terms relating to arbitration. What is arbitration? Both the parties will appoint an arbitrator, he will make a decision. And what is the arbitration agreement? The agreement in which both of them written and signed, that is the arbitration agreement. And then, who is the arbitrator? Both of them will select an impartial person and an independent person to decide the case. He will be the arbitrator. And then, types of arbitration we are going to see. These are the key terms which you have to know before starting arbitration. And then there are certain limitations for arbitration. Only certain small matters can be dealt with arbitration. For example, a big case like murder cannot be dealt with arbitration, and you have to go to a court always. And this is the list of matters that can be referred to arbitration. Civil disputes, breach of contract. Two parties make a contract and any one party is breaching it, not following the contract. Now in this case, the party who made a default, the defaulting party should pay damages to the suffering party. If you make a mistake, the other person will suffer. So, this defaulting party should pay damages to the suffering party. This amount of damages we have to compute. For that, we can appoint an arbitrator and it will be going through arbitration. And then, right to office. If you have a right to go to work somewhere and the employer is denying you from doing the work, this is your right to office. If you have the appointment letter, you can go to office and nobody can stop you. This is the right to office, and in that if you have any problems, you can go to arbitration. And then time barred claims. For example, you are getting a debt. You are getting a debt of rupees 1 lakh and you are not repaying it, and for a certain amount of period, the lender who gave you the money is also not asking you to return it, and after a certain period he cannot recover it from you according to the Limitation Act. Time barred, it is called as a time barred claim. For a claim, if you have to recover the amount, you have to go within a certain period of time. If you go beyond the certain period of time, you will not have any right to claim the amount. In such cases, you have to go to arbitration. It will be easy for you to negotiate and prepare a settlement between the lender and the borrower. These are the disputes that can be referred to arbitration. And there are certain disputes which cannot be referred to arbitration. As I said, murder, which is a criminal case, like that, criminal cases cannot be referred to arbitration. And then insolvency. Insolvency, we have a separate code called Insolvency and Bankruptcy Code that you cannot refer in arbitration. And then revenue matters, tax matters, GST, which you do not pay. There is a dispute between you and your government. This is a problem which you cannot solve by using arbitration. You have to go to court compulsorily. Now, these are the matters that cannot be referred to arbitration. This is the limitation of arbitration, but otherwise you can do arbitration for pretty much many matters. And the next thing we are going to see is the object of the Act. Now, this is the object of the Act. Arbitration and Conciliation Act 1996 was brought in with an objective to, it is an act to consolidate the law relating to domestic arbitration, international commercial arbitration, and enforcement of certain foreign arbitral awards. Now we have to know what is domestic arbitration, what is international arbitration, what is a foreign award, what is an arbitral award. First of all, we have to learn all these. So let us look at an example for learning this. First, we can see what is an arbitral award. In court, when you go to the court to solve a dispute, the court will make a decision and give it, and it will be called judgment. Like that, in arbitration, the arbitrator is equivalent to a judge and he will make a decision, and that decision is called as an arbitral award. Decision by the arbitrator is called as an arbitral award. In court we call it judgment, and in arbitration we call it arbitral award. This is the difference between judgment and arbitral award. Now you know what is an arbitral award, which is nothing but a decision by the arbitrator. Now next we have to see about domestic arbitration and international commercial arbitration. First, let us look at an example for international commercial arbitration. Now, for example, in the same cafe business, we can assume a different scenario. Instead of two persons from India running the partnership, we can have one person, Ram, who is an Indian citizen, who will be a partner, and the other partner is John, who is a US citizen, he is resident outside India. Now, if they have a problem between Ram and John, it will be referred to international commercial arbitration. Now, you can see the difference clearly between these two. When there are two Indian parties, this is a case of domestic arbitration. In case of two Indian parties, it is a domestic arbitration. But when one party is from India and the other party is from outside India, whether it be United States, whether it be United Kingdom, if the other party is from outside India, it is called as an international commercial arbitration. Okay, now at least one party should be from outside India. This is the basic thing. The definition we will be seeing later on in the chapter in detail. So, when two parties are Indian, it is a domestic arbitration. When at least one party is from outside India, it is an international commercial arbitration. That is the difference between these two. Now, let us learn about foreign award. Now, what is a foreign award? It is given under section 44. Before learning about foreign award, we need to know about New York Convention. New York Convention is an international convention which was brought internationally, and many countries are member states to the New York Convention. It is a convention for recognizing and enforcing foreign awards and foreign arbitration. Recognizing and enforcing foreign arbitration. Now, India is a member state to it. Now, this is the New York Convention and India is a member state. When we are going to learn about foreign award. Now, section 44 decides that foreign award is an award made in a place outside India. That is, it is seated outside India. What is a seat? That will be explained later. Now, the award is made in a place outside India, and for it to be a foreign award, the country where the award is made should be a member state of New York Convention. The award is made outside India, for example, United States. And the United States is a member state of the New York Convention. So, that award will be a foreign award. It should be made outside India, first condition. Second one, the country should be a member state. These are the two conditions for determining whether an award is a foreign award or not. Now, what is a seat? award should be made in the place outside India. That is, it should be seated outside India. Now, what is a seat? The concept of seat in arbitration is given here. It is the legal place of arbitration. When writing the arbitration agreement, you have to decide what is the seat of arbitration. What will happen if you decide the seat? It will determine the law applicable to the arbitration. According to which law you have to conduct the arbitration. This will be decided by the seat. If you select the seat as India, now the arbitration will happen according to Indian Arbitration Act. Now, if the place of seat of arbitration is decided as US, the arbitration will happen according to the United States law. This is the concept of seat of arbitration. It is a legal place of arbitration which will determine the law applicable to the arbitration, including the procedural aspects. Even the procedure will be according to the seat of the arbitration. Now, what is the seat of arbitration? How it will be related to domestic and international commercial arbitration? Domestic arbitration is how we are classifying it as domestic arbitration. Both are Indian parties. If at least one of the party is from outside India, then we call it as international commercial arbitration. While classifying the domestic arbitration, we see the nationality, whether they are Indian or outside India. This is what we see when we classify it as domestic arbitration. But when we have to see which law is applicable or which seat is there, for that we have to see the legal place. It will be mentioned in the arbitration agreement. A domestic arbitration which happens between two Indian parties may be Indian seated or may be foreign seated. That is, the legal place, it may be in India or the legal place may be foreign. And in the international commercial arbitration also, it is because at least one party is from outside India, it is an international arbitration. But the seat is, it can be India or it can be foreign. The legal place, they will be deciding in the arbitration agreement. So, this is the foreign award concept. Foreign award is an award made in a place outside India, that is seated outside India. This foreign award concept does not have any relation relating to international commercial arbitration or domestic arbitration. It is a seat-centric provision. Where the seat is, that is the important thing for the foreign award determination. If the seat is outside India and the member state and the outside India state is a member state of the New York Convention, then it is a foreign award. This is the simple definition for foreign award. Once again, I will recap what is the concept of seat of arbitration. Seat of arbitration is the legal place of arbitration which will determine the law applicable to the arbitration, according to which law the arbitration will be conducted. This will be based on the seat of arbitration. Domestic and international commercial will be decided based on the party. At least one party is outside India, it is an international arbitration. Both the parties are Indian, it is a domestic arbitration. Now, the seat, where the legal place is, where it is determined. It is determined in the arbitration agreement. If the legal place is India, it is an Indian seated domestic arbitration. If the legal place is outside India, it is a foreign seated domestic arbitration. And the arbitral award, decision of the arbitrator under a foreign seated arbitration will be a foreign award. And under international arbitration, if the legal place is in India, it is an Indian seated. If the legal place is in foreign, then it is a foreign award. Both domestic arbitration and international commercial arbitration can have a foreign award based on the seat which is given in the arbitration agreement. Now, this is the concept of seat. Now, let's get into the topic. For what we saw all this domestic arbitration, international arbitration, to understand the object of the Act. This Act contains the law relating to domestic arbitration, international arbitration, and foreign award enforcement. This is the object of the Act. Now, let us get into the topic in a detailed manner. Now, already we saw alternative dispute resolution process, negotiation, conciliation, and arbitration. Now, there is something called as conciliation. It is also similar to arbitration, but the decision is not binding. You need not compulsorily follow the decision of the conciliator. In the arbitration, we have the judge known as arbitrator. In conciliation, the name of the judge is called as conciliator, and the decision is not binding. You need not compulsorily follow. You may or may not follow. Now, this Act has 4 parts. Arbitration Part 1, Enforcement of Foreign Awards Part 2, Conciliation Part 3, and Part 4 is Supplementary Provisions. Arbitration, this Part 1, it has a scope, and the Part 2 has a separate scope. This will be discussed later in the chapter. And along with 4 parts, we have 7 schedules in the Act. For what we have sections and schedules separately, the section gives about the procedures and all the things about the Act, but some miscellaneous things are there which are not given in the Act. For example, the fees which is payable to the arbitrator, it is given in a schedule. Like that, minor things which are not a part of the Act but are necessary, it is given under schedule. You have to read the schedule separately. If you want to understand about the fees of the arbitrator, you have to read the respective schedule for that. This is the concept of schedule. And then, this is the object of the Act which we saw already. And then we can go into arbitration. Arbitration, as we saw earlier, is an agreement by which the parties agree to refer their matter to arbitration. 2 parties, they will solve their issue by arbitration. This is called arbitration agreement. It will be in writing. The person appointed to resolve the dispute, who will be solving the dispute, he is called as arbitrator under arbitration. Now, arbitrator will make a decision. It is called as an arbitral award. and there can be more than one arbitrator also. In many complex cases, more than one arbitrator are required, and more than one arbitrator is called as an arbitral tribunal. There will be a panel of arbitrators for huge complex cases. The next topic is Arbitration Council of India. It is an independent body in India for promotion of alternative dispute resolution, conciliation, negotiation, arbitration. These are all the alternative dispute resolution things, and it will be promoted by Arbitration Council of India. These are the functions: framing policy for guiding arbitral institutions. There is something known as arbitral institutions, which we will study down. Here down it is given, and we will study after seeing ACI. Create uniform professional standards. It will give professional standards for arbitrators. Like for chartered accountants, we have ICAI, and for company secretaries, we have ICSI. Like that, for arbitrators, we have ACI. For arbitrators, this is the function of ACI. And then maintain a depository of arbitral awards. There are thousands of arbitration cases going on in the country. Now we have to maintain a place where all the arbitral awards are collected, and if anyone wants to see their award, they can go there and see the award. For that we need a depository, and it is maintained by ACI. It will contain all the awards which are made under Arbitration Act of India. The next thing is arbitral institution. For example, if it is a small problem, we can go to a lawyer and we can appoint him as an arbitrator and solve the issue. But for every case, we cannot go and search for arbitrators. So there will be some arbitral institutions which will have their own rules. There will be big law firms who have lawyers with years of experience in the industry and the relevant field. They will have that arbitrators ready-made, and we can go to them, we can tell the issue to them. They will appoint a arbitrator panel. There will be more than one arbitrator. They will be in the law firm. They will be appointed to solve our dispute. We need not go and search for individual arbitrators. Since it is a law firm, the persons will be very experienced, and it will be proper when we go to a arbitral institution. Examples are Indian Council of Arbitration, International Chamber for Commerce, Delhi International Arbitration Center. These are the arbitral institutions, and the work of ACI, one of the function of ACI is grading arbitral institution. There are several arbitral institutions. The ACI will grade 1 arbitral institution, grade 2 arbitral institution, like that there will be grades. Grading means it is based on the performance, how much cases they are solving, how it is working, what is the operation of the arbitral institution, like that they will see and they will grade. This will be helpful to select the arbitral institution for people with disputes. For big arbitration cases, they will select arbitral institution with a very high grade. The grade will be given by ACI, as I said already. So this is the importance of grade in arbitral institutions. Now, arbitral institutions is over, and alternative dispute resolution, a short note is given. Methods of dispute solving that does not involve going to court. Other than going to court, you can use these alternative methods. Court is not in a position to bear the burden of entire judicial system. There are a lot of cases going, and they are pending because we do not have an efficient judicial system. It does not have a large number of judges. Only 21,000 judges are there approximately in India, and they cannot solve all the 3 crore cases. So we need an alternative dispute resolution mechanism like arbitration. And in arbitration, we have procedural flexibility. We can set the formalities according to our wish. There is no rigid formality like courts. And we saw about arbitration, object of the act, and the law is based on UNIFITRAL, United Nations Commission on International Trade Laws. This is a model law upon which we have created our own Indian Act. There is a model law, and we have made a modification to that and adapted it to our legal system as the Arbitration and Conciliation Act 1996. The main point is law is based on United Nations Commission on International Trade Laws. Now we can start the sections of the Arbitration and Conciliation Act. Section 1 is the short title, extent, and the commencement. This is not so important. You can read it from the book if you want. Now we are going to Section 2, definitions. The Section 2 contains definitions. Generally in all acts, Section 2 is dedicated for definitions. The first definition is for arbitration. Arbitration means any arbitration, whether or not by a permanent arbitral institution. Whether you appoint an institution for arbitration, or you appoint an individual arbitrator, or you appoint a panel of arbitrators. If the arbitration happens according to this act, then it is an arbitration. Then arbitration agreement means an agreement referred to in Section 7. The detailed definition of arbitration agreement is given in Section 7. We will read it later in the chapter. There is a summary given here according to Section 7. Arbitration agreement means an agreement by the parties to submit the disputes to the arbitration, all or certain disputes to the arbitration in respect of a legally defined relationship. One more important point is, where will the dispute be coming? There will be a legally defined relationship. For example, lessor-lessee relationship, seller-buyer relationship, owner-tenant relationship. These are all legally defined or contractually defined relationship. If there are problems or disputes between these parties, they can go to arbitration. Now, the next point is arbitral award. It is an inclusive definition. It includes an interim award. Generally, we saw that decision of arbitrator is the arbitral award. There can be many types of decisions. Final decision, once all the hearings and all the procedures are done, after all the procedures are done, the arbitrator will give a final award, which is the arbitral award. And it also includes an interim award. For example, still the case is not over, but for an interim award, we have to give a certain compensation or certain order which will be issued to facilitate the case. This is an interim award. This we will be studying in detail in section 9. What is an interim award? What is an interim order? This we will be seeing in section 9. Now, arbitral institution. Arbitral institution designated by the Supreme Court or High Court under the Act. This is also arbitral institution, like we saw International Chamber for Commerce. Like that, there are arbitral institutions. They will be designated by Supreme Court or High Court under the Act. This also we will be seeing later on, how the court will designate the arbitral institution to you. Now, next is arbitral tribunal, means a sole arbitrator or a panel of arbitrators. As we already saw, it may be a single person or it may be individual persons working under arbitral institution. It may be a panel, we saw already. Now, court, the definition of court. Under domestic arbitration, the word court defines civil court. Under international commercial arbitration, the word court means high court. For domestic arbitration, in the law relating to domestic arbitration, wherever the word court is written in the law, it refers to a civil court. But in the case of an international commercial arbitration, the word court refers to high court. This is the point here. Domestic arbitration refers to civil court, but in case of international, it is a high court. Now, the section 11 refers to appointment of arbitrator. This we will study along with section 11 when it comes in detail. Now, this is the appeal structure under the Arbitration and Conciliation Act. First, for domestic arbitration, the arbitrator will give an order in the first step. After this, if you don't like the order, only certain orders are appealable, which is given under section 37. Every order of arbitrator you cannot go and appeal. Only certain orders, the list is given under section 37. Only certain orders you can go appeal against. The appealable orders can be appealed in district court in the first step for domestic arbitration. First, the arbitrator will give the decision. You don't like the decision, you can go to district court. And you can go to high court if the district court also does not satisfy you. And the high court will give a decision. If that also does not satisfy you, you can go to Supreme Court for domestic arbitration. But for international arbitration, directly after the arbitrator's decision, you can directly go to high court. And the high court will give a decision. If you do not like the decision, you can go to high court divisional bench. And if you do not like that decision also, then you can go to Supreme Court. In case of domestic arbitration, since it will be small case because both the parties are Indian, the first step is for district court. But in case of international arbitration, one party is from outside India. Generally, when a party is from outside India, the case will be a little bit bigger than domestic arbitration. So, the first appeal is directly going to high court. This is the logic behind the appeal structure. And then we have the definition for international commercial arbitration in detail. As we saw earlier, at least one party must be from outside India. That the party may be individual. There may be two individuals contracting, or one party might be body corporate, a party might be company, or the other party might be government. There may be a dispute between one party, person, and a government. So these are the different types of parties. In case of individual, at least one individual must be national or resident outside India. He should be a national, US national, or he should be resident outside India. For body corporate, it should be incorporated in outside India. For it to be an international commercial arbitration. In case of company, at least one party who is a company should have central management outside India. Central management, the main decisions for the company should be taken outside India. In case of government, the government should be of a foreign country. At least one of the party, where the party is a government, the government should be of a foreign country. For example, the government of United States, the government of England, like that, it should be of a foreign country. At least one of the party must be foreign. Foreign in case of individual is resident outside India. Foreign in the case of body corporate is incorporated in outside India. In the company case, it is central management should be outside India. In case of government, it should be a foreign country government. This is the definition for international commercial arbitration in detail. The next point is legal representative. Now, what is a legal representative? Legal representative is one person who is incompetent or who cannot represent himself will be represented by another person. On behalf of the first person, another person will go and do the law things or legal formalities will be done by another person. Generally, it is done to appointed to represent the estate of the deceased. For example, one person dies. He cannot come and do the legal formalities as he is already died. So, you have to appoint another person to represent the estate of the died person. Now, we have an example for this. Let us see the example. This is the example for legal representative. For example, we can keep there is a family. Ram is the grandfather and Krishna is his son. Surya is his grandson. Now, Ram is a grandfather. He is already in an old age. Now, unfortunately, he dies. And when he dies, there are two types of situations which may happen. He may have written a will and he may not have written a will. When he writes a will, in the will it will be written that assets of Ram, the grandfather, will go to his son Krishna. If it is written like this, then Krishna will have all the assets which belonged to Ram during his lifetime. And in this case, the legal representative will be Krishna. If the will is not written, the court will appoint a legal representative. The assets of Ram will be taken over and it will be sold off, and if there are any debts or not, it will be seen, and the legal representative appointed by the court will pay off the debts due by Ram, and the remaining amount will be given to the legal hire. This is the work done by legal representative. In the case will not written, court will appoint the legal representative. The legal representative will consolidate the assets and pay off the debts if any. Now, this is the example for legal representative. Now, let's get into the definition for legal representative. This is the definition for legal representative. Legal representatives are agents having legal status. Following are examples of legal representatives. Person who represents an estate of the deceased person. As we saw, the person appointed by the court to look after the assets of Ram, the grandfather. And person who voluntarily intermeddles. And person on whom estate of the deceased devolves from the death. On that example, after the death of Ram, the grandfather, he has written a will and the assets have gone to Krishna, his son. In this case, the Krishna will be the legal representative because the estate of the deceased, the assets of Ram, came to Krishna on the death of Ram. This is the legal representative concept. Now, we are going to see section 2, subsection 2, the scope of part 1. Part 1 we saw, right, arbitration. The scope of part 1 is defined under section 2, subsection 2. This part shall apply where the place of arbitration is in India. The concept of seat of arbitration we saw now. That is the relevant concept here. Where the seat of arbitration is in India, part 1 shall apply. Where the seat of arbitration is outside India, the part 1 will not apply. But there is an exception to this. Provided that, subject to an agreement to the contrary, provisions of Section 9 interim measures, Section 27 court assistance in taking evidence, Section 37(1)(a) applies even when the place of arbitration is outside India. Generally, all the sections in Part 1 will apply only when the seat of arbitration is in India. But these are three special sections where the seat they will apply even to foreign seated arbitrations. Even if the seat is in a foreign country, the section 927 and section 37(1)(a) will apply. Now, this is the scope of part 1. Generally, part 1 will apply to where the seat is in India. But there are three special sections which will apply even when the seat is in foreign. Seat in outside India. Section 9, 27 and 37(1)(a) will also apply even when the seat is outside India. This is the scope of part 1 given in section 2, subsection 2. Now, this was also told in the case law, Bharat Aluminium and Company versus Kaiser Aluminium and Company. This is an important case law in the Arbitration Act. The Honorable Supreme Court laid down the landmark judgment that part 1 will also apply to foreign seated arbitration. Generally, domestic seated only arbitration which have seat in India will have to follow part 1, or part 1 will apply only to arbitration with seat in India. But for foreign seated arbitration, these three sections will apply. This is given in the landmark judgment. Now, the next thing we are going to see is arbitration agreement. The detailed section for arbitration agreement, section 7. As I told, we are going to see the arbitration agreement conditions. Now, it is an agreement by parties to submit to arbitration. This is the third time we are seeing this sentence, and I hope all of you remember what I told. In the form of a clause or a separate agreement, the parties decide the arbitration, and the arbitration agreement can be in the form of a clause or a separate agreement for arbitration. You are putting a main contract, the purchase agreement or a rent agreement, whatever the main contract you put, it may be separate. But the arbitration agreement, there are two types of including the arbitration agreement in the main contract. Either you can put it in the main contract in a separate place in the main contract, or you can make a separate agreement for arbitration, and that agreement will contain full and full only about arbitration. These are the two types, in the form of a clause or a separate agreement. It shall be in writing. This is compulsory. If you make oral agreement, it will not amount to arbitration agreement. It should be in writing. There should be a document. It should be written, and both of the parties should be signing the document. Only then it will constitute a valid arbitration agreement. Otherwise, it will be invalid. What and all will be considered in writing? It is a document signed by parties. It will come under writing. Exchange of communication through electronic means. For example, if you order a product from a cake shop or something like that through WhatsApp, and in WhatsApp the reply message comes from the shop owner that all the disputes will be C will be solved using arbitration, and this person will be the arbitrator, and all the things are given. This is a message which was received by you through WhatsApp. You cannot say this is not in writing, because under writing, exchange of communication through electronic means, that is like WhatsApp messages, are also covered under writing. Exchange of claims of statement and defense alleged by one party and not denied by other. Then, for example, if you send a legal notice to the other party, and you are saying that there is arbitration clause or arbitration agreement, and the other party does not deny it. He is not saying that no, there is no arbitration, like that he is not saying. So when you say that there is arbitration and the other party does not deny it, then it is also covered under writing. Exchange of statement of claim and defense alleged by one party and not denied by other. One party is saying that arbitration is there and the other party is not objecting it, then this will also constitute writing. Then reference to document arbitration agreement if contract is in writing and reference is such to make the arbitration clause a part of the contract. For example, you make a contract. There is a main contract for rent agreement. This is the main contract. In that main contract, there is a line giving that Annexure 6 is for arbitration. Annexure 6 is for arbitration. Now, Annexure 6 is the document, separate document, but you are giving reference of that in the main rent agreement. What is the intention for giving the reference? You are saying that we are going to solve the dispute by arbitration. For that, we need an arbitration agreement that is given in Annexure 6. Now, this is the clear intention behind referencing the Annexure 6 document arbitration agreement into the main contract of rent agreement. Now, when you give reference like this, it will also be a valid arbitration agreement. Now, this section is over, section 7. Now, let's recap once again what and all we have saw in the section. It is an agreement by parties to submit to arbitration. Okay. It may be in the form of a clause or a separate agreement. In the main contract, it may be a clause or it may be a separate agreement also. It should be in writing. It may be like a document signed by parties or like WhatsApp message, electronic means communication, and then exchange of claims of statement and defense. It may be in any of the three parts, and if it is in any three, if it is coming under any one of the three things, it will be considered as writing. And then reference to document arbitration agreement. You are remember you are giving reference of an extra document which is separate, and the intention is to make it as a part of the contract. Now it is also an arbitration agreement, valid arbitration agreement. Now the next section is section 8, power to refer parties to arbitration where there is an arbitration agreement. For example, there are two parties, A and B. The A is the seller and B is the buyer. Now these two get a dispute. Now they have to solve it through arbitration. They already have an arbitration agreement. They have entered into arbitration agreement already, and that agreement is there. But buyer, what he does is he directly goes to court. He does not refer to arbitration. Now when he goes to court, the other party A should also come to court and explain his the arbitration agreement. If a matter is referred to court, arbitration agreement is already in existence, then the other party can raise an objection in the first statement of defense. When the court is asking A, what should you do, what is happening, they will ask the explanation statement from A. A, in his first statement of defense, the very first argument, the first thing that he tells in court should be that we have an arbitration agreement and we will solve through arbitration. If he tells like that, we are going to do through arbitration and there is an arbitration agreement, the court would be barred to take up that matter. Then that matter cannot go through court and we have to go through arbitration only. For this thing to happen, you have to tell that there is an arbitration agreement and the wish of and your wish to solve through arbitration in the very first statement of defense. The first argument should be there is an arbitration agreement. If this is happening, then the court cannot take up the matter and you can solve through arbitration. This is given under section 8. Now there are relevant case laws to this section which we will be seeing one by one. Hindustan Petroleum Corporation Limited versus Pink City Midway Petroleum. Explanation. The court is barred when a timely objection is made under section 8. As we saw earlier, the party should make in the very first argument that there is an arbitration agreement and we will solve through arbitration. This is given under this case law. And Mahesh Kumar versus Rajasthan State Road Corporation. Here in this case law, it is given that mere existence of the arbitral clause does not bar the court automatically. In the example also, there was an arbitration agreement, but just because there was an arbitration agreement, the court is not barred from taking that matter. The other party should make up in the very first argument that they have an arbitration agreement. Only if the argument is made, then the court will be barred from taking up that matter. If the other party does not say about the arbitration agreement, then the court can take up the matter without any problem. Objection must be raised not later than submission of first statement of defense. The very important point here, why I am stressing this so much is, this is the very important point in section 8. The very first argument, the first statement of defense should contain that there is an arbitration agreement and we are solving through arbitration. This is the first argument that should be there if you want to solve through arbitration. Now, we saw that under section 8, subsection 1, you can, in your very first argument, you can tell that there is an arbitration agreement and go to arbitration. Now, under section 8, subsection 2, when you have to make the very first argument of arbitration agreement, you need to have the proof that arbitration agreement was made. The proof is original arbitration agreement or the duly certified copy thereof. You should have the original agreement in hand. Only then you can go and say that there was an arbitration agreement. So, this is the condition for saying the first argument. But if you do not have the original agreement and it is with the other party and the other party has gone to court, he will definitely not give you the original arbitration agreement. Now, what you can say is that the party who does not have an original arbitration agreement, he can tell to the court that I do not have the agreement. The other party who has come and filed a case with you, he has the original agreement. And the court will order the other party to produce the arbitration agreement. And you need not produce the original agreement. The other party will produce it on behalf of you, because that is the court order. So if you have to go through arbitration and there was an agreement, but you do not have the original copy of it, you can tell to the court that the other person has it, and you can get an order from the court to produce the document by the other party. This is given in 8 subsection 2. Now this is the end of section 8. Let us once again we can summarize what we saw in section 8. If a matter is referred to court, already there is an arbitration agreement. You have to give in the very first argument that we have an arbitration agreement. Then for giving that very first argument, you need the proof of arbitration agreement. That proof is the original arbitration agreement. If you do not have the original arbitration agreement, you can tell to court that the other party is having it, and the court will order the other party to produce it. That's all about the section 8. Let's start with section 9. Section 9 is about interim measures. In the previous video, we saw that it is one of the 3 special sections where part 1 will also apply when the seat of arbitration is outside India. Generally, part 1 will apply only when the seat of arbitration is in India. But there are 3 special sections, one of which is section 9. It will also apply even when the seat is outside India. Now let's get into the topic. Interim measures for appointment of guardian for minor or unsound person. First of all, what is an interim measure? In an arbitral institution or arbitration, we will get an arbitral award. In that, there are 2 types of arbitral awards. One is final arbitral award and the other one is interim arbitral award. Final is the final decision after all the hearings are done. It is the final outcome of the arbitration. And interim award, it is done before the final award. It is given to facilitate the case or to preserve the subject matter or certain things which have to be done before the final award. For those things, we are giving an interim award. In section 9, the interim award will be given by court. Let us see an example to understand the interim measures in a deeper manner. For example, we can assume there is a contract between 2 persons, Ayush, who is a seller, and Bharat, who is a buyer. The seller is selling electronic goods to Bharat, and Bharat has to make payment for it. Bharat receives the electronic goods but does not make payment. The reason he is telling is that the goods are defective, so I will not make payment to you. Like that Bharat is saying. He is saying that the goods are damaged. Ayush is saying that the goods are not damaged and you have to make the payment. Now this dispute is submitted to arbitration. If this is a dispute in a legal relationship or contractual relationship, so they are going to arbitration. Now in arbitration, Ayush, the seller, fears that the buyer may damage the goods before arbitration. Before going to arbitration, now the goods is in the custody of Bharat. If he destroys the goods, then it is a loss for the Ayush. So Ayush is fearing that he might damage the goods. So he has to protect the goods. He cannot go and protect the goods which is in Bharat's custody, buyer's custody. Now he have to go to court and request an interim measure under section 9. This is the usefulness of the interim measure. Before going to arbitration, you can get certain orders from the court for facilitating the case. Now Ayush, the seller, goes to court and asks for preservation of goods. The seller asks the court to give an order that the buyer should protect the goods and preserve it before the arbitration starts. Before arbitration starts, he cannot sell off or destroy the goods. And freezing the bank account of Bharat. Buyer, if he does not have any money, the seller cannot recover any money. So, in order to secure the amount from Bharat, he has to get an order from the court to freeze the bank account. If the bank account is freezed, then no one can take the amount, and if the arbitration comes in favor of the seller, he can recover the amount from Bharat, the buyer. And he can also request a security deposit. For example, if the payment due is rupees 50 lakhs and the dispute is submitted to arbitration, they can ask the buyer, Bharat, to make a deposit. He has to make a deposit of rupees 50 lakhs in the court. If the arbitration comes in favor of Ayush, the amount will be going to seller, Ayush. If the arbitration comes in favor of Bharat, the buyer, then the 50 lakh will be returned to buyer. This is the case for interim measures. This 50 lakh security deposit is a measure which will help to run the case effectively. If if you do not make the security deposit, there is an uncertainty that whether the buyer will pay the amount or not. Now when the amount is deposited to the court, if the arbitration comes in favor of seller, nobody can stop the amount from going to seller. This is the topic of interim measures. Now we can see the definition which is given in law. This is the definition given under law. Interim measures can be used for appointment of guardian or for minor or unsound person. For example, in an arbitration, if one of the parties is a minor or an unsound person, he cannot manage the affairs himself. So we need to appoint a guardian for managing his assets, or the arbitration he has to manage by himself, the guardian. The interim measure can also be requested for preservation of the subject matter. Like in the example we saw, for preserving the electronic goods, the seller got an order from a court. Like that you can get an order from court. Securing an amount in a dispute. Like that in the same example, we got a security deposit of rupees 50 lakhs. That is the meaning for securing the amount in a dispute. We have a dispute, for getting the amount, we are getting a deposit and securing the amount. If the arbitration comes in favor of the seller, the amount is very certainly it will be given to the seller. Detention, preservation or inspection of documents. For example, if there are documents related to arbitration and any party may damage it or destroy it, you can have a order from the court for inspection and preservation of the documents. Appointing a receiver. This is also an order which can be received from court by using section 9. If the court passes an interim order, arbitral proceedings shall be commenced within a period of 90 days of such an order. We have a dispute, and for that dispute, we are going to arbitration. Before the arbitration, we are getting the interim measure. After getting the interim measure, we cannot wait for a very longer period, because the subject matter will be being preserved, the amount will be deposited, and the buyer cannot wait for a long period to get back the amount. So, we have to start the arbitral proceedings quickly after getting the interim measures. The period of time limit is 90 days. After getting the interim measure, within 90 days, we have to start the arbitral proceedings. The next point is, once the arbitral tribunal is appointed, court cannot entertain application under section 9(1). Before going to arbitration, we can get interim measure from court. But once the arbitral tribunal, the arbitrator is appointed, now you can get whatever the interim measure you want, you can get it from the arbitrator. You need not go to court. We got to court in the first case because there was no arbitrator appointed and the arbitration has not started. Once the arbitral tribunal is appointed, you can go to arbitrator. Unless the court finds that the remedy under section 17 may not be effective. For example, the court gave an order for preservation of electronic goods in the above example. This is an order given by court. If the same order has to be given by tribunal, it will be given under section 17. This interim measure section 9 is for courts. Court can give interim measure under this section. For tribunal, arbitral tribunal to give the interim measure, it should give under section 17. So, this is the section for tribunal. If the tribunal cannot give, or if the remedy under section 17 given by the tribunal is not effective, then court can take up the matter under section 9 and it can give interim measure. Otherwise, generally, arbitral tribunal should give the interim measures once it is appointed. The important point in this section is, for these measures, we can get an order from the court, and after the order, within 90 days, the arbitral proceedings should be started. But after the arbitrator is appointed, we cannot go to court under section 9. The next section is section 10, number of arbitrators. These are all the sections which we will be seeing later, which will be under arbitral tribunal section. This will all be about the arbitral tribunal, the composition, the number of arbitrators, etc. Section 10, number of arbitrators. Parties are free to decide, but it cannot be an even number. In this case, the parties can appoint the arbitrator themselves, whether it be 11 arbitrators or 13 arbitrators. If you want 3 arbitrators, or if you want a single arbitrator, you can also appoint a single arbitrator. But it cannot be an even number. The problem is that if you appoint 4 people as arbitrators, 2 people will be in favor of party 1. 2 people will take decision in favor of party 2. Now, who will take the final decision? It will end up in a tie, and we cannot solve the problem easily. So, we have to appoint an odd number of arbitrators. In case of odd number of arbitrators, 2 persons will be in favor of party 1, 1 person will be in favor of party 2. In this, the majority decision will be prevailing. We can take the decision of majority and give it as an arbitral award. So, we have to appoint the number of arbitrators only as an odd number. Then, procedure for appointment of arbitrators. Empowers court to designate arbitral institutions which are graded by ACI. If you want to appoint arbitral institution, you can go to court and you can make an application to the court. We want an arbitrator. The court will designate arbitral institutions which are graded by ACI. They will give you certain arbitral institution. These are all the arbitral institutions. You can choose from this. Like that, they will give a list, or they itself will give you this arbitral institution will take up your case. Like that, the court will designate the institutions for you. For appointment of arbitrator, in case of domestic arbitration, if you want an arbitrator, you have to go to High Court and get an order. In case of international commercial arbitration, if you want to appoint an arbitrator, you have to go to Supreme Court. You have to go to court, you have to make an application, and then they will specify or designate arbitral institutions to you. And they will appoint an arbitrator and see the administrative work for your case. Now we can see the subsections of Section 11. Section 11, subsection 1, nationality. Any nationality unless otherwise agreed. The arbitrator you are appointing, right, whether it should be Indian or it should be a United States citizen or it should be a England citizen, like that, the nationality of the arbitrator is the question here. Any nationality of arbitrator can be appointed unless otherwise agreed. For example, in your arbitration agreement, it is written that the arbitrator should be a US citizen or a US national. He should be an arbitrator. Then in that case, you cannot appoint an arbitrator of Indian origin. You have to go by the agreement. If there is no such agreement, then you can appoint any nationality like you want. Procedure for appointment as decided by the parties. In the arbitration agreement itself, you have to decide by what procedure you will appoint the arbitrator, how you will select the arbitrator, which arbitral institution you can go. Like that, there is a procedure which will be decided by the parties mutually when preparing the arbitration agreement. The main point is arbitration agreement. Everything will be specified in it. If something is given in arbitration agreement, you have to follow it. You cannot go against it. The next point is in case of 3 arbitrators. Each party will appoint 1 arbitrator and the 3rd arbitrator will be appointed by the 2 arbitrators already appointed. Let us see an example to understand this point. For example, in arbitration there are 2 parties, party 1 and party 2. In case of, if you want 3 arbitrators to be appointed in the dispute, party 1 will appoint A1, 1 arbitrator will be appointed by party 1, and 1 party will appoint 1 arbitrator. The second party will appoint 1 more arbitrator. Totally now there are 2 arbitrators. For the 3rd arbitrator, who will appoint it, party 1 or party 2, both of them will not appoint. The already selected arbitrators A1 and A2, they will jointly appoint arbitrator 3. This is the case in case of 3 arbitrators. First arbitrator appointed by 1 party, second one appointed by another party, third one will be appointed by the 2 arbitrators already selected. This is given under section 11. Next point under section 11 is subsection 3a, arbitral institutions. Courts have power to designate arbitral institution. If you go to court and ask for an arbitrator, the court can designate arbitral institutions to take up your case. This is given under section 3a. Appointment of arbitrator by arbitral institution in case parties fail to appoint arbitrator. If a party fails to appoint an arbitrator within 30 days of request from other party. We have an example for understanding this. Let us go to the example. In this example, there are 2 parties, party 1 and party 2. Party 1 is sending a request to party 2. They got a dispute and they are going to solve to arbitration. Party 1 is sending a request letter to party 2 to appoint the arbitrator. He is giving the work for appointing arbitrator to party 2. Party 2, he has to appoint the arbitrator, but he does not appoint within 30 days of request. In this case, the arbitrator is not appointed. And there is another case also. There are 2, in case of 3 arbitrators, we already saw that the 3rd arbitrator will be appointed by the already selected 2 arbitrators. For example, in the same example, we can assume that party 1 appointed an arbitrator, party 2 also appointed an arbitrator, but these 2 people should together appoint a 3rd arbitrator. That 3rd arbitrator is not appointed within 30 days. 30 days is the time limit. Whether the parties are appointing or the arbitrators are appointing within 30 days, if they do not appoint, then 11 subsection 4 will apply. Now let us see what is given under the section text. In the section text, it is given that if a party fails to appoint an arbitrator within 30 days or 2 arbitrators fail to appoint a 3rd arbitrator within 30 days, what will happen is that the appointment shall be made by arbitral institution designated by court on an application by a party to the arbitration. On an application by party. Now let us understand what this is saying. If the arbitrator is not appointed within 30 days, either by the parties or by the first and second arbitrators, what will happen is a party to the arbitration can make an application to the court. Now what the court will do is that court will designate an arbitral institution. Court will be saying that party, you cannot appoint the arbitrator because you are not allowed to appoint after 30 days. You are coming to us for an arbitrator. Now we are designating an arbitral institution like the International Chamber of Commerce to take up your case. The arbitral institution will appoint an arbitrator for you. You don't need to search for arbitrators. The arbitral institution will also appoint within 30 days. Court will order the arbitral institution and the institution will appoint the arbitrator within 30 days. This is the procedure. This is the procedure given under section 11 subsection 4. This is an important section and all the appointment under section 11 will be made under section 11 subsection 4. We will be studying it later. This is the procedure for appointment given under section 11, subsection 4. Subsection 5, what it is telling is that appointment of arbitrator by arbitral institution in case parties fail to appoint sole arbitrator. Single arbitrator also parties are unable to appoint. They did not appoint within 30 days. Appointment shall be done in accordance with subsection 4. The procedure we saw will apply. And subsection 6, appointment of arbitrator by arbitral institution in case parties fail to follow agreed procedure. I already told that there will be an arbitration agreement, and in that there will be everything about the arbitration, including the procedure to appoint the arbitrator. The parties already decided a procedure and wrote that in the arbitration agreement. If that procedure is being followed and any one party fails to act by the procedure, and or the parties for two arbitrators fail to reach an agreement under the procedure, or a person fails to perform work entrusted under the procedure. First thing is, any one party is not following the procedure. Then also this will not, you cannot appoint an arbitrator properly. The parties or two arbitrators already appointed, they cannot follow the procedure and select an arbitrator. There is a problem in selecting arbitrator under the procedure. A person fails to perform work entrusted under procedure. For example, in a procedure, there are two parties, party 1 and party 2. There is one work which is given to party 1 and one work which is given to party 2. If they two do their work properly, then we can follow the procedure and we can appoint an arbitrator properly. In case party 1 does not follow the procedure and does not do the work entrusted to him, then what we can do? Then this also comes under section 11, subsection 6. In these cases, what will be done is appointment shall be made by arbitral institution designated by court. Same, section 11, subsection 4 procedure will apply. The party will go apply to the court. Court will designate an arbitral institution, and the arbitral institution will appoint an arbitrator. Then section 11 subsection 6a is omitted. Subsection 6b, what it tells is that designation of arbitral institution not to be regarded as delegation of judicial power. The court, what it is doing, that it is simply appointing an arbitral institution. It is not delegating any of its judicial powers. Under a constitution, a court cannot give any of its powers, which is called delegation of powers. There are certain powers which is given to court, and court cannot outsource it to anybody and tell them to do the work of court. This is not possible under the constitution. So the court will appoint an arbitral institution just to take up the case, not giving any of the judicial power to the arbitral institution. It is just appointing to take up the case. Subsection 7 is omitted, and subsection 8, disclosure regarding independence and impartiality from the arbitrator. We already saw that the arbitrator should be very independent and impartial. He should not be he should not show partiality for any party. Arbitral institution, before appointing an arbitrator, shall seek a disclosure from him in terms of section 12, subsection 1. Under section 12, subsection 1, we will study what are the disclosures to be given before being appointed as an arbitrator. For example, you are being appointed as an arbitrator. You have to give certain disclosures and sign it, and you have to give it to the parties before being appointed as an arbitrator. Like it is an agreement to be an arbitrator, like that. You will be given a disclosure that you should fill it and give it. The qualification as agreed by the parties contends that he is independent and impartial. In that declaration what you are giving, it should have the qualification agreed by the parties. For example, in an arbitration agreement, it is written that the arbitrator should be a chartered accountant. Now, if you are appointed as an arbitrator, you have to give the declaration that I fulfill the qualification. I am a chartered accountant and I can be an arbitrator as per the agreement. And you have to also include that I am independent and impartial. This is the thing given under subsection 8. Subsection 9 is in case of appointment of sole or third arbitrator in an international commercial arbitration. In an international commercial arbitration, where at least one party is from outside India, the arbitral institution may appoint the arbitrator in a different nationality than the parties. For example, there is one party who is from USA, and there is another party who is from India. Now the arbitrator, whether he should be a United States person national or whether he should be an Indian, this is a problem. For example, if the arbitrator is appointed as a USA person, it will be in favor of USA person. If the arbitrator appointed is Indian, he will go in favor of the Indian person. Now this is a problem. So we have to appoint an arbitrator in a different nationality than the other parties. Now you can appoint an arbitrator as an Australian. This will not cause any problem. He will be impartial and independent, and he will be a center, and he will not go in favor of any party. The next point is subsection 10, which is omitted. Subsection 11, request to too many arbitral institutions. The arbitral institution to which the request has been first competent to appoint. For example, you give request to different arbitral institutions. You give to International Chamber of Commerce. You are giving to a law firm. Like that, you are giving many requests to many arbitral institutions. Now, which arbitral institutions will appoint the arbitrator? The first arbitral institution to which you gave the request, and along with the request, it should also be competent to appoint. It should be an arbitral institution recognized by the ACI. Competency means Arbitral Council of India. This will recognize the arbitral institutions. If the arbitral institution is recognized and you also gave a request, the first arbitral institution which has both of these will be competent to appoint. Then subsection 13, application for appointment under this section must be disposed of within 30 days. The process we saw, right, you are a party, you will go to court, court will designate an arbitral institution and the arbitral institution will appoint an arbitrator. This should be happening within 30 days. Fees determined by arbitral institution subject to rates specified in the 4th schedule. The arbitral institution is appointing an arbitrator for you. It is doing a service. You have to give fees to that. They are also having a very big structure. They also have expenses. For getting that, they are appointing an arbitrator and charging fees from you. The arbitral institution can charge fees from you, but it is subject to the rates specified in the 4th schedule. We saw that there are sections and schedules separately. In schedule 4, it is given that there is fees to the arbitral institution. You can get fees from the parties, but subject to schedule 4 rates. There will be maximum fees, only this much you can get. You can get minimum fees of this much, like that. Those rules should be complied. Those rules are given under schedule 4. The next section is section 12, grounds to challenge the appointment of arbitrator. Before appointing an arbitrator, you are getting a disclosure. But after appointing an arbitrator, if you want to challenge the appointment, no, this arbitrator is not right, the appointment is not valid. Like that, if you are saying, how to say that, what is the procedure to challenge, on which grounds you can challenge, what is the basis on which you are challenging, that is also given under law. Arbitrator, before appointment, he should give a disclosure. This is the section 12 subsection 1 which we saw already. The disclosure should be in this format. Any past or present relationship or interest in the parties, giving rise to justifiable doubts on independence and impartiality. There are certain relationships. If the arbitrator has any relationship, he is related to the party, he will have an partiality towards that party. So he cannot be appointed as arbitrator. There are certain relationships which is given in the 5th schedule. There are schedules in the 5th schedule, the certain relations are given. For example, father, mother, like that, there will be relations given under 5th schedule. Those relations, if the arbitrator is related to the party by that relation, then it will give a doubt on the impartiality and independence of the arbitrator. So he should give an disclosure that I had this much relationship, or I did not have any relationship with the parties. Like that, he should give a disclosure in writing before appointed as an arbitrator. And the second disclosure is any circumstance likely to affect his ability to devote time and complete the arbitration within 12 months. Generally, the arbitration must be completed within 12 months. Since it is an alternative mechanism and the main problem is quicker solution will be reached here. This is the reason many people choose arbitration. The maximum time limit is 12 months. Within the 12 months, the arbitration should be completed. For example, if you appoint a renowned lawyer, he is a very experienced lawyer, and you appoint him as an arbitrator. He is a very busy lawyer. He is practicing somewhere, and there are lots of clients for him. And if he is in that situation, he cannot give time to your arbitration and solve your dispute. Within 12 months, he cannot do it. If such a situation exists, he should give it in the disclosure before being appointed as an arbitrator. First disclosure regarding the relations with the parties. The relation will be given in 5th schedule. Second one is that whether he will be able to devote time for the arbitration and complete it within 12 months. These are the two disclosures under section 12 subsection 1. And the disclosure should be made in a form given in the 6th schedule. The disclosure should be made in a separate format, the format given in 6th schedule. The next thing is section 12 subsection 2. Arbitrator must disclose to parties in writing about the circumstances. He should give the disclosure. An arbitrator may be challenged. You can challenge the arbitrator appointment only if circumstances exist to give justifiable doubts on impartiality. If you have a doubt that he is acting partial towards any party, and you have the basis, you have the circumstances as a proof. Now in this case, you can go and challenge the appointment. He does not possess the qualification agreed by the parties. Like that, we said in the arbitration agreement, if it is given that the arbitrator should be a chartered accountant and the person appointed is not a chartered accountant, you can go and challenge the appointment. That we have agreed that one day a CA should refer our dispute. You are giving it to a non-chartered accountant. Like that, you can go and challenge. Only under these two grounds, you can challenge the appointment of an arbitrator. A party may challenge an arbitrator only for reasons which he got aware after appointment. In case of appointment of arbitrator, the parties only are going to appoint it mutually. Both of them will discuss and they will appoint. Arbitral institution will also appoint, but in many cases, mutually the parties will be appointing the arbitrator. If you are agreeing to the appointment, and at the time of appointment, you know that there is a relation between party 2 and relation between arbitrator and a party. Now this you know while you are signing for the appointment. Now after after the arbitrator is appointed, you cannot challenge by saying that there is a relation between arbitrator and party. You know that there is already a relation. By knowing this also, you are agreeing and appointing him as an arbitrator. Now again you cannot challenge him by reasons for relation between arbitrator and party. This is given under subsection 4. Subsection 5 is not so important, but still I will read it. Notwithstanding any prior agreement to the contrary, any person whose relationship falls under Schedule 7 is ineligible for appointment as arbitrator, provided that the parties subsequent to dispute being arised can waive the applicability of this subsection. There is a schedule called Schedule 7. In that there are certain relationship given. If the arbitrator is any one of the relationship given under Schedule 7 with the parties, then he cannot be appointed as arbitrator. Now, if this is the main point and it is notwithstanding any prior agreement, even the agreement is even the arbitration agreement allows the relation, the Schedule 7 is not allowing. So the act is superior and you should not follow the arbitration agreement and you should follow Schedule 7 in that case. Notwithstanding the agreement, Schedule 7 relation person should not be appointed as an arbitrator, provided that the parties subsequent to the dispute being arised can waive the applicability of this section. For after the dispute got arised, there are two persons, party 1 and party 2, they got a dispute. They have an agreement and after that they are having a dispute. After the dispute arised, the party can mutually waive this subsection. They can say that we will not follow this section, like that they can say. This is the proviso to this subsection. Let us summarize once again what we studied under section 12. Grounds to challenge an arbitrator. Arbitrator should disclose two things. First one, relationship with the parties. Second one, the time, whether he will be able to devote it or not and complete within 12 months. Then the subsection 2, what it is telling is that the disclosure should be made. Subsection 3, whether if there are doubts on the impartiality and he does not possess the qualification, you can challenge the arbitrator. Subsection 4, a party may challenge an arbitrator only for reasons she got aware after appointment. If you know the reason before appointment itself, then you cannot challenge the arbitrator based on that reason. Subsection 5 is not so important. The next section is section 13, challenge procedure. Now you have decided to challenge the arbitrator. Now which procedure you will follow, that is also given under law. The parties are free to agree on the procedure. While preparing the arbitration agreement itself, you have to write in that what will be the procedure to challenge the arbitrator. Like that you have to write the procedure. Any party who intends to challenge within 15 days after getting aware of the constitution of the tribunal, send a written statement of reasons to challenge the tribunal. For example, a tribunal is appointed. In that there are three persons, person 1, person 2 and person 3. You got aware of the tribunal constitution. You are getting a notice that your dispute has been referred to tribunal. In the tribunal, these persons are the arbitrators. Now you know the tribunal composition. Now if you do not have an agreement with the tribunal, you are not agreeing with the tribunal. You are saying that person 2 is a relation. He is a father of the other party. Now what you have to do? You are have to challenge the arbitrator. For that, after you know that party 2 is person 2 is appointed, within 15 days, you should give a written statement of reason to challenge the tribunal. You have to send a letter in that you have to write the reasons. These are the reasons. For these reasons, I don't want person 2 to be appointed as an arbitrator. And the second is, if the challenge is unsuccessful, arbitral proceedings shall be continued. You are challenging, and if the challenge is unsuccessful, they are telling that the relation is not there or the relation has ended, like that they are telling, then the challenge will be unsuccessful. But the party can make application to set aside the award under section 34. The arbitral tribunal, if the challenge is unsuccessful, the arbitral tribunal, if the challenge is unsuccessful, it will continue the proceedings and it will pass an arbitral award. If you don't want the award, you do not agree with the award, you can go to the court and file an application under section 34. This is an application to set aside the award. This award is not proper. You have to set aside the award or cancel the award. Like that, you can go and apply to the court under section 34. Now this is the procedure for challenge. The parties can agree on the procedure. You should send a written statement of reason within 15 days of you got to know that the tribunal is appointed and the challenge is unsuccessful. They will be passing an award and you can give an application of section 34 to set aside the award. The next section is section 14, failure or impossibility to act as an arbitrator. If the mandate or office of arbitrator shall terminate, if he becomes de jure or de facto unable to perform. For example, if the arbitrator is unable to perform, he cannot conduct the arbitration due to law reasons or due to factual reasons. For example, if you are appointing a person as an arbitrator and he robbed a bank, now the police arrested him and he is in a jail. Now you cannot ask him to come and conduct the arbitration. He is by law and by fact he is unable to perform. He cannot conduct the arbitration. Now the office of the arbitrator is terminated. The arbitrator is ended and you have to appoint another arbitrator for the case. The office of the arbitrator is also terminated when he withdraws from the office or when the parties agree for his termination. He himself comes over and tells that I am withdrawing from office. I will not see your case. Like that he is telling. Then also the office is terminated. Then another case is the parties agree for his termination. There are two parties. Both the parties agree together and tell that this arbitrator should not be there. Like that they together agree and terminate the office of the arbitrator. This is also a case where the office of the arbitrator will be terminated. If controversy regarding inability to perform, you are not able to find out whether the arbitrator can perform or not, you can go to court and file an application. The court will look at the circumstances and decide whether the arbitrator can perform or not. This will be decided by the court. If you cannot determine it, you can go to court and file an application. Now, section 15, substitution of arbitrator. The mandate shall terminate when he withdraws or the parties agreement. Same like that. When it terminates, substitute arbitrator shall be appointed. When an arbitrator is removed or the mandate or office is completed, substitute arbitrator will be appointed. Unless otherwise agreed, previous hearings may be repeated at the discretion of the arbitral tribunal. For example, one person is an arbitrator. In between, he withdraws from the office and you are appointing another substitute arbitrator. Now, any hearing which happened during the previous arbitrator, it may be repeated at the discretion of the tribunal. Now, the new arbitrator asks that you have to conduct the hearings again because I do not know anything about this case. If he asks like that, then you have to repeat the hearings. Unless otherwise agreed, order or ruling made prior to substitution shall not be invalid merely due to substitution. For example, you can take that there is an arbitrator. He passed certain orders, order 1, order 2, all these are orders which the previous arbitrator passed. Now he withdraws from the office and another substitute is appointed. Now after the new arbitrator is appointed, whether the orders previously passed, whether they are invalid or valid. This is the question here. The law says that it is valid. It is not invalid just because a new arbitrator is appointed. The previously passed orders are valid. This is the point in this section. Let's recap what is given in section 14. The office of the arbitrator shall terminate if he is unable to perform. It is also terminated when he withdraws or the parties agree. If you are not unable to determine that whether he is able to perform or not, you can go to court and file an application. Substitution of arbitrator. The substitute arbitrator will be appointed if an office of the arbitrator terminates. Now the previous hearing may be repeated or may not be repeated. The orders made by the previous arbitrator will not be invalid merely because of the substitution. Next, section 16, jurisdiction of arbitral tribunal. Arbitral tribunal, what is the meaning of the word jurisdiction? The extent to which the tribunal can make orders. Up to this limit, the arbitral tribunal can make orders. Or there are very, very big orders which the arbitral tribunal cannot make. The tribunal does not have the power to investigate these matters. Like that, there will be certain things. This is called the jurisdiction. The extent to which an order can be passed by the arbitral tribunal. The extent to which an order can be passed. This is the arbitral tribunal jurisdiction. Arbitral tribunal is empowered to decide its own jurisdiction. The arbitral tribunal will contain lawyers and people experienced in law. They can decide their own jurisdiction. Arbitral tribunal can decide if the arbitration agreement is valid or null and void. When the arbitral tribunal is appointed, the lawyers in the tribunal can decide whether the agreement for arbitration, whether it is valid or whether it is null and void. They can decide it. Objection can be raised that the tribunal lacks power to do the adjudication of the matter. For example, there are certain matters, point 1, point 2, point 3. These three matters are the dispute which you are referring to the arbitral tribunal for arbitration. Now, arbitral tribunal passes orders on all the three matters. Now, you got a doubt and you are telling that the point 2 is there, that matter is beyond the jurisdiction of the arbitral tribunal. This is a very big matter and you cannot pass orders on this, like that you are telling to arbitral tribunal. Now, the arbitral tribunal will take this into consideration and they will also decide whether they have jurisdiction or not. You have to give the objection as soon as the matter is raised. As soon as the matter is starting to be investigated by the arbitral tribunal, you have to tell this objection that you do not have the jurisdiction. If the tribunal deems that the matter is fit for arbitration, it can pass awards as it may deem fit. If the arbitral tribunal decides that no, I have the jurisdiction and I will pass an order, it will pass the award and it will pass the award as it may deem fit. If you do not like the award, you have to file an application under section 34 for setting aside the arbitral award. You cannot stop the arbitral tribunal, but you can make an application for setting aside the award. The next section is section 17, interim measures by arbitral tribunal. Like we saw section 9, like preservation of subject matter, appointment of receiver, appointment of guardian for unsound person. Like that, these are the measures. It is same as section 9. Section 17 also contains these measures, but these will be provided by arbitral tribunal. Under section 9, it will be given by court. This is the difference, but mainly all the contents are same. Section 18. Equal treatment of parties. The arbitrator should treat all the parties equally. Suppose there are two parties, both the parties should be treated equally. For example, if notice is given for party 1 prior to 7 days, party 2 also should be given notice prior to 7 days. You cannot give the party 2 notice for 4 days or 5 days, you cannot give. If party 1 is given 7 days, party 2 should also be given 7 days. Like this, in every aspect, equal treatment must be done for the parties. Determination of rules of procedure. Tribunal is not bound by CPC 1908, Code for Civil Procedure. The tribunal should not follow the Code for Civil Procedure. There is no compulsion for the tribunal to follow the Code for Civil Procedure, or the Indian Evidence Act also it need not follow. Then, the place and commencement of arbitration. Parties are free to decide the place of arbitration. Place in this act, wherever the word place comes, it means the seat of arbitration. The concept of seat of arbitration is explained in the previous video. The parties can decide the seat of arbitration by themselves. Upon failure of the parties, the tribunal shall decide. If the parties do not decide, then the tribunal will decide. Section 21. Commencement of proceedings. When the proceedings will commence? On the date on which the request for dispute to be referred to arbitration is received by respondent. For example, we can take that there are two parties. They got a dispute and they are going to refer it to arbitration. Party 1 is sending to party 2 a letter. In that letter, what is given is that we are having a dispute and it will be referred to arbitration. The date on which the party 2 receives the letter. This is the date on which the proceedings commenced under section 21. The next section is section 22, language of arbitration. You can decide any language which is comfortable to the parties and the arbitrator. Generally, it is in English. Section 23 to 27 talks about the procedure for arbitral proceedings. Once the proceedings started, how it will be going on, what is the procedure, like that the section 23 to 27 will be discussing on that aspect. Section 23 talks about statements of claim and defense. It shall be completed within a period of 6 months from the date of arbitrator receiving the notice of appointment. Now, party 1 and party 2 will together appoint an arbitrator. The arbitrator will receive the notice of appointment. Like that, you are appointed for taking on the dispute and solving the case of these two parties. From this date, you have to go and do the work. Like that, there will be a notice of appointment. From that date, within 6 months, the first part should be completed. What is the first part? Statement of claim and defense. Claim is that the problems will be given and allegations will be made on the other party. Defense is that I did not do that, like that the other party will tell. For example, party 1 is giving allegations. This is called statement of claim. And party 2 is saying that no, I did not do that. Like that it is the defense. These two are the statements given by both the parties. This statement giving should be completed within 6 months. The next section is section 24, hearings on written proceedings. Tribunal shall hear both parties and claims. The tribunal can hear oral arguments unless otherwise agreed. Tribunal can hear oral arguments. There is no restriction on that. The claims and defense submitted by the parties in step 1, it will be heard by the arbitral tribunal, and the second step. All the statements and documents given by tribunal to one party shall be communicated to the other party. For example, there are two parties. The tribunal is giving some kind of document to party 1. Now tribunal should also inform party 2 that I have given this document to party 1. Like that, the communication of documents should be coordinated very properly. For this coordination, individual arbitrators are, if the individual arbitrators are appointed, party 1, party 2 and arbitrator, these three of them should make the coordination. But if you appoint an arbitral institution, the arbitral institution will make all the facilitation of documents, the communication, everything will be seen by the institution. For this reason, the administrative work is done by institution. Many of the people appoint arbitral institutions. The next section is section 25, default of party. In the same way, if one party is giving a document to tribunal, now this document party 1 has given, this should be communicated to the party 2. This is also done in the second step. Now the third step is default by party. If any party defaults in performing acts, tribunal may take action as it may deem fit. The defaults are without sufficient cause. The claimant fails to communicate the statement of claim. We saw that in the first step, the person should give statement of claim. If the person does not give the statement of claim, what the tribunal will do? Tribunal shall terminate the proceedings. The tribunal is appointed to take up the case. The claim itself, first step itself you are not giving, then what the tribunal can do? It will terminate the proceedings and stop the case. The next point is when the respondent fails to communicate the statement of defense. First party gave the claim, but the second party is not giving the defense. Now, in this case, what will happen is tribunal shall continue the proceedings. The first stage is completed. The defense only it is not giving. It will be taken that the party is not giving defense and it will continue without getting the defense statement. For example, if the party fails to produce evidence or appear at an oral hearing, the tribunal gave a date for oral hearing and it told that all the parties relevant should come there. And if one party is not coming to the oral hearing, the tribunal shall pass award as per available evidence. The party would have been called to the oral hearing to provide some evidence or give some fact or give some explanation. Now, if the party did not come to oral hearing, the tribunal will carry on and proceed as per the available evidence. These are the problem. When there is a default by party, the tribunal will take the following actions. Then there is section 26, expert appointment by arbitral tribunal. For example, there is a software agreement, and in that agreement there is a dispute between two parties. In that case, they will appoint an arbitrator, and the arbitrator may not be very well knowledgeable about the software. Since it's a technical field, the lawyer will not be able to understand the software details. The party 1 and party 2 are IT companies. They can understand the software things. Now, for making it easier for the tribunal, they will appoint a software expert. He will come to the hearing and give the explanation regarding the software agreement and the technicalities. This will be done under section 26, expert appointment by arbitral tribunal. Tribunal may appoint experts to report on specific issues. Parties shall give access to necessary informed document. If the software expert comes, both the parties should give the information to the expert. Only then the expert can analyze and give his views. Section 27, court assistance in taking evidence. Tribunal may apply to court for assistance in taking evidence. For example, in some cases, the tribunal may require some evidence. This evidence may not be always available to the parties. It may be available at a bank or it may be available at a court. Like that, the evidence will be in several places. For the tribunal cannot go in each place and get the evidence. For that, the place owner will not give the permission. So we need a formal court order to go and take the evidence. Let us see an example to understand how this works. This is an example for section 27. For example, we can take that there is an owner of a house. He is giving his house on rent. There is a rent agreement and the tenant is Arjun. They both have an rent agreement and they both also have an arbitration agreement. Now, after some months, the owner comes and tells the tenant to vacate because of non-payment of rent. The owner is saying that you are not even paying rent. I am not receiving any amount from you, so you have to vacate the house or the shop, whatever the building is, you have to vacate it. Like that, the owner is saying. The tenant is saying that I have made the payment through bank and I have the bank receipt. From my account, the amount has been debited. Now I have done the payment, but so I should not vacate. I will not vacate. Like that, there is a dispute. The arbitrator is appointed and he requires evidence for payment from the bank. The Arjun is from a different bank, tenant is from a different bank, and the owner has a different bank account. Now the tenant has given his bank details that the amount has been debited, but the owner bank account, whether the amount is credited or not, that there is a confusion. So the arbitrator requires evidence of the owner's bank account details from the bank. The bank will not give the account details of the customers so easily. So we need a formal court order to obtain the evidence of bank payment from the bank. Now for this we can get court assistance to obtain the record of payment from the bank under section 27. We have to make an application under section 27 and we can get a court order for obtaining the evidence. This is the relevance of section 27 in a practical situation. Now, in the section it is given that tribunal may apply to court for assistance in taking evidence. The court will execute the order by ordering the evidence to be produced to the tribunal. The court will order to the bank that to produce the relevant documents to the tribunal. Person refusing to give evidence will be guilty of contempt of court. If the court is ordering you to give evidence, but you are not giving the evidence, you will be guilty of contempt of court. You are not respecting the court's orders. This will be contempt of court. The next section is section 29, decision. Whenever the arbitration decision, it will be taken by a majority of members. For example, there are 3 arbitrators. The majority decision, the decision of 2 arbitrators will be taken into count. The one arbitrator who gave an opposite decision, it will not be taken. The majority decision will be given as an arbitral award. In the previous video, we have completed up till section number 29. But if you closely watch the video, I have skipped a section, which is section number 28. We will be starting today's session from section number 28. Let's read the text of the section. Rules applicable to the substance of the dispute. Section 28(1), where the place of arbitration is situated in India. As I already said, the word place is equivalent and used by meaning the word seat. We saw the concept of seat of arbitration in the first video that we uploaded for the Arbitration Act, where the seat of arbitration is in India in an arbitration other than international commercial arbitration. So, this means domestic arbitrations. For domestic arbitration, where the seat of arbitration is in India, the arbitral tribunal shall decide the dispute submitted in accordance with the substantive law for the time being forced in India. In this section, what they are saying is that this is a domestic arbitration. That is other than international commercial arbitration, and both of the parties are Indian parties. and the seat is also in India. So this should be decided according to the Indian law. And the subsection 28(1)(b). In an international commercial arbitration, the arbitral tribunal shall decide the dispute in accordance with the rules of law designated by parties as applicable to the substance of the dispute. In case of domestic arbitration, where the seat is in India, it should be decided by Indian law. In case of international commercial arbitration, here also the seat is in India, but it should be decided by the rules as applicable to the dispute designated by the parties. In the arbitration agreement, the parties will have written that which law will be applicable, according to which law the arbitration should happen. This will be given in the arbitration agreement. That rules you have to follow. Any designation by the parties of the law or legal system of a given country shall be construed as directly referring to the substantive law and not to its conflict of laws. When the parties have written in the arbitration agreement that it is referring to the USA law, we will be conducting the arbitration according to the USA law, then you have to conduct according to the US law. This is the simple meaning of this point. Failing any designation of law under clause A by the parties, the arbitral tribunal shall apply the rules of law as it considers to be appropriate, given all the circumstances surrounding the dispute. Here, in this section, the law has given the power to the parties to designate the law. Which law they have to follow, they can choose it. But if they do not choose any law, the tribunal will decide which law to follow. They will decide the appropriate law and conduct the arbitration according to it. The arbitral tribunal shall decide ex quoto, ex bono, or as amiable compositure only if the parties are expressly authorized to do so. Many times when we decide the issue, we will be strictly following the law. This is one type of approach, strictly following the law. And there is another type of approach where we will not be strictly following the law, but we will be giving the decision based on fairness and equity. Here we will see the fairness and whether it is right or wrong. In that sense, we will be taking the decision. If we strictly follow the law, it is an approach. If we decide based on fairness and equity, it is another approach. Here, the meaning of this Latin term is deciding based on fairness and equity. The arbitral tribunal can decide the case based on fairness and equity only if the parties expressly authorize the tribunal. The parties should tell the tribunal that you can decide the case based on fairness and equity. Generally, in other cases, the arbitral tribunal should strictly follow the law. And only when the parties expressly expressed, then you can follow it based on fairness and equity. While deciding and making an award, the arbitral tribunal in all cases take into account the terms of the contract and the trade usages applicable. In every transaction or every field, there will be certain trade usages that you have to take into account while making the decision. That is while giving the arbitral award. There is also terms of the contract. There will be a main contract. For example, purchase agreement or rent agreement or sale agreement. There will be a main contract. In that contract, we are getting a problem. That is why we are going to arbitration. So, in the main contract also, that also you should consider while making the arbitral award. Now I have given a summary of section 28 here, where the place of arbitration is in India. That is, the seat of arbitration is India. There are two cases other than international commercial arbitration, that is domestic arbitration, and the international commercial arbitration is the second case. In case of domestic arbitration, the arbitration should happen according to the law in India. In case of international arbitration, the law will be designated by the parties, or they will not designate the law will not be designated by the parties. If the law is designated by the parties, the rules of law will be as applicable as designated by the parties. The law designated will refer to the substantive law of the country. If the law is not designated by the parties, the appropriate law will be decided by the arbitral tribunal. And subsection 2, based on fairness and equity, the tribunal can decide the case only when the parties expressly authorized. They have to give in writing or in oral, they have to tell it. The arbitral tribunal cannot follow it automatically. It should also take into account the terms of contract and the applicable trade usages for the transaction. This is all about section 28. Let's move to the next section. The next section is section number 29A. This is given for time limit of arbitral award. Arbitral proceedings we are going to because we are not preferring the court because of the time delay. We need quick solutions under arbitration. That is why we are coming to this alternative dispute resolution method. So we have capped the time limit for up to 12 months. We should complete the arbitration within 12 months. From which date you will calculate this 12 months time period? From the completion of pleadings. As we saw already, while in the arbitration proceedings, we have 4 steps like statements of claim and defense, hearing and proceedings. Like that we have 4 steps. In that, the step 1 is called statement of claims and defense. This is called completion of pleadings. all the claims will be settled, and after that the hearings will start. This when the date on which the step 1 is completed, that is the date from which you have to calculate the 12 months. If the statement of claims and defense is completed on 1st April, then from that you have to add the 12 months. For example, the statement of claims and defense is completing on 1st April 22. From that you have to calculate 12 months. Then 1st April 23 will be the time limit for the arbitral award under section 29A. The next point is parties consenting can extend the time period for a period not exceeding 6 months. For example, in a case, the time limit is completing on 1st April 23. Up till 1st April 23, they have not given an arbitral award. So now what we can do? We can extend the period. For how much period we can extend? We can extend up to 6 months. If the award is not made within the time, within the 12 months or within the 18 months, if it is not made, what will happen is the arbitrator will be terminated. The office of the arbitrator will end and we have to appoint another arbitrator. And if the award is not made within time, another problem is also there. There will be reduction of fees, maximum 5% if the award is not given timely. That is not a flat 5%, it is a 5% for each month of such delay. For example, if the arbitration fees is 1 lakh rupees and you have made 5 months of delay, 5% of the fees, 5,000, will be deducted for every month of the delay. That is meaning that 5,000 is for 1 month of delay. We have done delay for 5 months. So totally 25,000 will be the reduction in fees. So 1 lakh is the early decided, 25,000 is the reduction. Now in the end you will get only 75,000 fees. This is given in section 29A. Additional fees for timely award. As we are giving punishment, reduction in fees for a late award, we have to give an incentive or a gift like that for timely award. If an award is made within 6 months from the date of arbitral tribunal entering, additional fees as the parties may agree. The date on which the tribunal enters the case, like the date on which it is appointed, from that if it is completed within 6 months, the arbitral award is given within 6 months, then additional fees will be given to the tribunal as the parties may agree. This will be decided by the parties. How much additional fees we should give, that will be decided by the parties. The extension for 6 months we told, right? Earlier the period will be 12 months and if it is not completed, you can extend up to 6 months. This 6 months extension will be given only if sufficient cause exists. Only if there is a proper reason behind the delay, only then the 6 months extension will be given. For getting the 6 months extension, you have to apply to court. And when you apply to court, the court will see whether you have a proper reason or not. The court may take a decision to substitute the arbitrator. The court may say that this arbitrator is not working properly. We can make another arbitrator and decide the case. We will give you 6 months extra. Like that the court can tell. The new tribunal shall be deemed to be in continuation. When the old arbitrator is going and we are getting a new arbitrator, he will be deemed to continue the case. He need not start from first. He need not start from scratch. The next point in this section is application for extension should be disposed of by the court within 60 days. If you apply to the court for extension, within how much time the court will give you the order? If you apply on 1st April 23 to the court for extension, the court can maximum give you the order within 30th May 23. Only 60 days is the time for court to decide whether you have to give the extra 6 months or not. Time limit for an arbitral award under section 20A is given under two circumstances. If the arbitration is a domestic arbitration, it is normally 12 months. There is no change in that. But in the case of an international commercial arbitration, the time limit is not capped to 12 months. There is no limit for time, but you should try to complete within the 12 months. This is a loosening condition, or it is given a relaxation under section 29A for international arbitrations. Since the case is bigger, we cannot restrict the timeline. So this is the logic behind the difference in time limit. The next section is section 29B. This is a fast track procedure. In court, when you go, it will take years to complete. When you come to arbitration, primarily under section 29A, you can complete it within 12 months. 12 months primarily, and within 6 months you can get to further extension period. If you want to even more quicker solution, you can go to fast track procedure under section 29B. What is the fast track procedure? In this procedure, you will get the award within period of 6 months. And there is no extension under this section. In the 29A, we got an extension up to 6 months. In this, no extension. The time limit is capped within 6 months. The maximum time limit is only 6 months. There will be no oral arguments. Since we have to decide it faster, we can take only written arguments will be taken. Everything should be written and it should be given. Otherwise, it will not be taken into consideration. There will be a sole arbitrator. If you want to decide the case quickly, it should be a small case. Very big complex cases cannot be decided quickly. So when you can have a small case, you can go under this section and there will be only one arbitrator. Award not given within time, section 29A will be applicable. If you cannot complete within 6 months, then what will happen? That section 29A will apply and you can complete within 12 months and you can get an extension of 6 months also. If 29B cannot complete within 6 months, then you can go to 29A. Oral arguments may be allowed by the tribunal if all party makes request or the tribunal considers it necessary. Generally, there are no oral arguments. If you want oral argument, all the parties concerned in the arbitration must make a request to the tribunal. Or else, if the tribunal considers it necessary, if the oral argument is required, like that the tribunal is thinking, then it can allow for oral argument. In the 29B fast track procedure, the fees and the manner of payment. For the fees, it is for the arbitrator. How much it should give, in what manner it should be decided, what manner it should be paid. This will be determined by the parties. The next section is section number 30, which talks about settlement. Tribunal may use mediation, conciliation and other procedures to encourage settlement. Tribunal will try to settle the arbitration dispute within you people itself. They will use mediation, conciliation, and they will try to patch up and settle the dispute between you two. If during proceedings parties settle the dispute, tribunal shall terminate the proceedings. For example, if both the parties talk with each other and they come to a negotiation and they come to a settlement, you will pay this much, I will give this to you, like that they will come to a settlement. If the settlement is reached, the tribunal will terminate the proceedings. If the settlement is reached, the tribunal will terminate the proceedings. The proceedings will not happen further and the settlement is reached. If the parties request and not objected by tribunal, settlement may be recorded as an award. For this arbitration dispute, there is no award because the settlement is reached. If the parties request, both the parties should request the tribunal and the tribunal should have no objection. Then what will happen is the settlement itself will be recorded as an award. Then this will be given to the parties. The settlement will be given as an arbitral award as an outcome of the arbitration. The award passed under section 31 and stated as an arbitral award. This award they are giving it, right? This according to which section they will give? According to section 31 they will give the award. Then it is an arbitral award. Same status as any other arbitral award. Just because there is a settlement here, there is no special recognition or there is no special things for this award. This will be the same status as any other arbitral award. The next section is section 31. Form and contents of the arbitral award. When the arbitral tribunal is giving an award, in what format it should be, what are all the necessary elements in the arbitral award, this is given under section 31. It should be made in writing and signed by the tribunal's members. All the members of the tribunal, the judges, right, the arbitrators who are present in the tribunal, they should sign the arbitral award. If there are more than one arbitrators, the signature of majority of the members is required. If there are 3 arbitrators, then in the arbitral award, the mandatory thing is at least 2 people's signature should be there, majority. 2 out of 3 people's signature should be there. And one person, if the signature is not there, it is not a problem. But there should be reasons. The reasons should be given in the arbitral award. That's all. And the next point is award shall state the reasons upon which it is based, upon which conclusion they came to the award. That thing they have to give in the arbitral award. There are certain situations where the reasons is not required. If the parties agreed that no reasons are required, then it will not be there in the award. If the award is under section 30, agreed terms, we saw it according to settlement, the award will be made. If the award is made by settlement, then no reasons should be given. Award shall state the date and place of arbitration, where the arbitration happened, the date on which it happened, that should be given in the award. Signed copy should be delivered to each party. It should be delivered to each party. If there are 2 parties, both of them will get 1 copy of the arbitral award. Tribunal may make an interim award. It may give an interim award also under section 17 for preservation of subject matter or for preservation of documents or for freezing the bank account, like that. Award of interest. Interest may also be awarded if the tribunal decides the interest is required. Tribunal may award interest. Interest at the rate of 2% more than the prevailing rates. As on the date of award, there will be an interest rate. Add 2% to that rate, you will get a percentage. That percentage interest the tribunal may award from the date of award to the date of payment. For making late payment, this is the penalty interest. Costs to be fixed by the tribunal. Any costs if are to be paid by any party, like that will be decided by the tribunal. The next section is for costs. You can read it in the book if you want. It is not so required, so I am not covering it here. Please do not avoid this section. You can read it in the book. 32. Termination of proceedings. Arbitral proceedings shall be terminated by final award or under section 32 subsection 2. There are 2 types of termination of arbitral proceedings. One is by above we saw award. If the final award is given, then the arbitral proceedings will be terminated. Or else under section 32 subsection 2, which will be studying down. Here it is. Under this section also we can terminate the arbitral proceedings. What is being said under subsection 2? Tribunal shall issue order to terminate the proceedings. Under 3 situations, the tribunal will give an order to terminate the proceedings. Claimant withdraws the claim. In the arbitration, we will have 2 parties. or there will be many parties also. For simplicity, I am taking two parties. One party will make allegations on the second party. This is the problem, and for this only we are going to the arbitration. This allegation we have to prove, or we have to get compensation, or if the allegation is wrong, we should tell the party that allegations are wrong. For this only we are going to arbitration. If the allegation itself is withdrawn by party 1, then there is no need for arbitration. Parties agree for termination. Both of the parties come mutually and say that we don't want proceedings. Please terminate the proceedings. Like that they are saying to the tribunal. And the next situation is tribunal finds that the continuation is unnecessary or impossible. In certain situations, the continuation of the proceedings will be impossible. For example, in any case, if it is a arbitration for some kind of goods dispute, if the goods are destroyed by kind of a natural calamity, then it is unnecessary, and it may be impossible also in some situation to continue the arbitral proceedings. In those cases, the tribunal will issue an order to terminate the proceedings. The next point is for correction and interpretation of the award. If there is any mistakes, or if there is any point which is confusing in the award, you can get an interpretation from the arbitral tribunal. Award may be corrected by the tribunal within 30 days of receipt of the award. The date from which the party receives the order, from that date you can add 30 days. That is the time limit for correction by the tribunal. Party must request to correct any computation errors or clerical or typographical errors. There are two types of correction on its own by the tribunal. The tribunal itself can notice the mistake in the order and they can rectify it by themselves. Or there is another method on application by the parties. The party will make an application to the tribunal. There is a mistake in the order. Please rectify this. Like that. The party must request to correct the computational errors. For example, it is written in the arbitration award, it is that 2 plus 2 is equal to 5. This is a computational error which should be corrected. For this, you can make an application to tribunal, and then any clerical or typographical errors can also be corrected. A party can request tribunal to give an interpretation of a specific part of the award. If you do not understand any part of the award, for example, if the award has 5 paragraphs, you do not understand one paragraph, in that you can go to the tribunal and ask the meaning for that one paragraph. Tribunal may correct or give interpretation within 30 days. Once you go to the tribunal and say that you have to correct the award or you have to make an interpretation, the tribunal will complete that work within 30 days. It will give an interpretation or make a correction within 30 days it will do. Period for correction may be extended by tribunal. The general time limit is 30 days, but the period of correction may also be extended by the tribunal. If the tribunal wants, it can extend the period also. And one more important point is, when you ask the tribunal for correction or for interpretation, you should give the notice to other party also. One party, if he comes for the tribunal correction or interpretation, it should give notice to the other party also. The next section is section 33, subsection 4, arbitral award, additional arbitral award. Section 33, subsection 4. Unless otherwise agreed, a party may request the tribunal to make an additional award as two claims presented in the proceedings but omitted from the award. For example, if you go to arbitration and you are giving 5 problems, 1, 2, 3, 4, 5. These 5 problems we need a solution from the tribunal. But the tribunal investigates and passes an award. But only 4 issues solution are given in the award. Now you can go to the arbitral tribunal and get an additional award for the 5th point which is not covered in the award. Such request within 30 days of receipt of arbitral award. For this also the period is 30 days only. When you receive the award, within 30 days from that date you have to go and ask the additional award. Tribunal for making the additional award, the time for tribunal is 60 days from the request. The date on which you give the request plus 60 days. That is the time limit for additional award. For example, you give the request on 1 April 22. It is given 60 days, that is 30th May 22. This is the time. Within this period, the tribunal should give the additional award. It may also be extended. The next section is section number 34, application for setting aside the arbitral award. This is the section which is very important for setting aside the award. You can go to court, and if you do not like the arbitral award, you can make an application and the court will decide and it will say whether the award is correct or not. Subsection 1, recourse to court can only be done by application to set aside award according to subsection 2 and 3. How you have to make the application, that is given under subsection 2 and 3. Award can be set aside only if, under which grounds, under what basis, by what underlying thing you can go and file the application. That is given here. Applying party furnishes proof that a party was under incapacity. If any of the party of the agreement or arbitration was under incapacity, he was unable to make any decision. If it is proved, then you can make an application to the section. Arbitration agreement is not valid, or party making the application was not given proper notice of appointment of arbitrator, arbitral proceedings, or was unable to present his case. If you were not properly represented in the arbitration, then also you can go. By you are not given the proper notice for the appointment of arbitrator, you are not given proper notice for the arbitral proceedings, you was unable to present the case. In this situation, you can give an application under section 34 for setting aside the award. You can also apply for lack or excess of jurisdiction. The arbitral tribunal made orders for matters which are beyond its jurisdiction. The arbitral tribunal does not have authority to decide on certain cases. That cases also, if the tribunal decides and gives an award, you can go to court for applying for arbitral award, setting aside. Award deals with dispute not falling within the arbitration terms. In the arbitration agreement itself, it is not given that this issue can be decided by the tribunal. If that also the tribunal decides, then you can go to court. Decides on matters beyond the scope of arbitration. Composition of tribunal or procedure not in accordance of agreement. The tribunal composition, for example, in the arbitration agreement, it is given that one chartered accountant and one cost and management accountant will be the arbitrators. But if this is not followed, both of them are chartered accountants, or both of them are company secretaries, or both of them are cost and management accountants. In this case, you can go to court under this section. The next point is that if the courts find that in the above case, what we saw is that the party will apply to the court and it will furnish the proof. In this case, the application is required from the party. There are certain cases where there is no need for application. The court itself will set aside the award. The grounds are subject matter of dispute not capable of settlement by arbitration. For example, there is a murder case. This is settled by arbitration. This is a matter which should not be settled by arbitration, and you have to go to court compulsorily. If this is a case, then the court will set aside the award on section 34. Award is in conflict of public policy of India. If the given arbitral award is opposed to the public policy, then also the court will set aside the award under this section. There are two explanations for this section. Before that, we should understand that these are the discretionary powers of the court. The court need not mandatorily do it, but the court can do it. There is a power with the court for doing this action. Explanation 1. Conflict with public policy. What is the meaning by conflict with public policy? Award was induced with fraud or corruption. If there is fraud or corruption, then it is opposed to the public policy. Contravention with the fundamental policy of Indian law, against the basic notion of morality or justice. It is immoral or it is illegal, like that. If it is there, then it will be set aside by court. Explanation 2. Test to contravention of fundamental policy may not entail a review on the merit of the dispute. What is the meaning of review on the merit of the dispute? The meaning is that if you go into the details, what is the dispute, what did the claimant say, what did the respondent do, what did the arbitral tribunal follow the proceedings, you should not go into the details. For seeing whether it is opposed to the fundamental policy, you should look only at the award and you have to make a decision. You should not go deeper into the details. This is the meaning of explanation 2. The next point is patent illegality. Award may also be set aside if there is patent illegality is found. If the award is blindly illegal, if we can see it and we can decide that it is illegal, it is so apparently illegal, then you can set aside the award. The next point is time limit to challenge an award. In this case, what are you doing is that challenging the award. You are make an application to set aside the award. Application shall not be made after 3 months from the date of receiving the arbitral award. The date on which you receive the arbitral award, within 3 months you have to go and make this application. If sufficient cause found, court may entertain application within further period of 30 days. 3 months is the general period. If you have proper reason, the court will also take into account delay of 30 days. It will give you 30 days extra time to make the application. Court may adjourn the proceedings if it deems necessary. Court may also adjourn the proceedings if it requires the proceedings to be adjourned. Application under this section be filed after notice to other party. If you want to file an application under section 34 for the arbitration, you have to give notice to the other party also, accompanied with the other party affidavit. The other party should also give an affidavit that he gave a notice to me. Like that, you have to get an affidavit also. The application must be disposed within a period of 1 year. For example, if the court receives the application on 1st April 22, it should be disposed of within 1st April 23. This is the time limit for taking a decision under section 34. Time limit for court. The next section is section 35, finality of the arbitral awards. The arbitral award given by the tribunal shall be final and binding on the parties claiming under it. And the next section is section 36, enforcement. It should be enforced as if it were a decree of the court. For example, if a court issues the order, in what way it will be implemented? The same way the arbitral award will also be implemented. For example, an arbitral award is given and you go to court under section 34 for setting aside the award. Just because you gone to the court, the implementation of the award will not be stopped. It will be implemented if only if the court gives a stay. Expressly, the court is giving a stay to stop the implementation. Only then the award will not be implemented. No automatic stay of the arbitral award. It will be generally implemented, no matter whether you file the case under section 34 or not. The next section is section 37, appealable orders. We have found in section 34 that you can challenge an award and you can go to court for setting aside the award. But you can go to appeal only under certain orders. I already told that the list is given under section 37. This is section 37, appealable orders. You can go to appeal only against these orders. Refusing to refer parties to arbitration under section 8. Granting or otherwise of measure under section 9. Setting aside or otherwise of order under section 34. Under section 8, the court can refer the parties to arbitration. If the order under that section by the court, whether they are referring you to arbitration or not, if you want to appeal to that order, you can make an appeal. Under section 9, you will go to court for an interim measure. If the court grants you interim measure or does not grant you interim measure, you are aggrieved, you are not satisfied by the decision, you can go to court for this appeal. Setting aside or otherwise of order under section 34. If you go under section 34 for setting aside an arbitral award and the court is telling, I will not set aside this award, the award is proper, you can go to the appeal. The next point is that an appeal against tribunal shall lie accepting the plea under section 16 subsection 2 or 16(3). Section 16 was for jurisdiction of the tribunal. Remember, the jurisdiction of the tribunal can be decided by the tribunal itself. If you say that the tribunal does not have the jurisdiction, it is up to the tribunal to decide whether the jurisdiction is there or not. If the tribunal takes a decision on this and you have to go and appeal on that decision, you can go under this section 37. Granting or otherwise of measure under section 17. Under section 17, interim measures will be given by the tribunal. If the tribunal refuses to give you the measure, you can go to court and get an appeal. No second appeal shall lie from above appeal. Under this section, if you are going to an appeal and that decision is the final decision, you cannot go another appeal on the decision under section 37. The next section is section number 40. Arbitration agreement not discharged by death of the party. Arbitration agreement is not discharged by death. Even if any one of the party dies, the case will be carried on by the legal representative or the legal hire and it will not end. Mandate of arbitrator is not discharged by death. If any one of the party dies, the mandate of arbitrator, the office of arbitrator will not be terminated. Nothing can affect the operation of law. This is the operation of law and no one can affect it. The next section is confidentiality of information. Section number 42A. Maintain confidentiality except award where disclosure is necessary. You have to maintain the confidentiality. One of the main reasons where we come to arbitration is for confidentiality of information. You have to keep the things in secret. Only when the award is given, you have to mention the details in the award. Otherwise, you have to keep the details confidential. This instruction is for arbitrator, the parties, and the arbitral institution also. They should keep the things confidential. The next section is section number 42B, protection of action taken in good faith. No legal proceedings against arbitrator for having done something in good faith or intended under this act. If the arbitrator does something in good faith, you cannot make a case against him for doing that action. The good faith of the arbitrator protects him from any cases being filed on him. Now there is one more section called section number 43 which talks about the limitation period. This is not so important and you can read it in the book. That's all. This is the end for chapter 4, the fundamentals of arbitration. The chapter 2 of the Arbitration and Conciliation Act as given in the CA final self-paced online module set C. Happy learning. Please revise this topic in regular intervals before your set C examination. Thank you for watching this video. Thank you. Now we can see the chapter enforcement of foreign awards. In this chapter, there are many things which you are going to see. First one is the types of arbitration. What are the different types of arbitration? Second one is types of arbitral awards. In these arbitration, award will be given. What are the types? That also we will be seeing. And then the enforcement of foreign awards. New York Convention and the Geneva Convention that we will be going to see. In this chapter, these two parts which covers the major portion, types of arbitration and the arbitral awards. This is just for clarity purpose. Different types of arbitration are given, but this covers the major portion of the chapter. You need not remember this word by word. You have to just understand the concept, and in these also many similar points are there. It will be very easier for you to see this chapter. Now we can get into the chapter. First thing is types of arbitration. Ad hoc arbitration, institutional, domestic, international, contractual, statutory, fast track, foreign arbitration. In this fast track we already saw in section 29B under the first part of this chapter, arbitration. We saw two sections, 29A for normal timing and 29B fast track procedure. This we will be seeing again in this chapter. The first type of arbitration is ad hoc arbitration. What I will be saying this in a short manner. Every arbitration I will be explaining it short. If you want it in detail, you can go into the details and study this. Now here in this ad hoc arbitration, what is the main thing is the arbitrator. It will be appointed by the parties itself. You will not go to an arbitral institution. We saw arbitral institution like International Chamber of Commerce. You can go to them and appoint the arbitrator. Here the arbitrator will be appointed by the parties itself. You will not go to the arbitral institution. This is the main feature in this arbitration. Here the parties will not dispute, they will arbitrate themselves, they will manage the arbitration themselves, they will itself appoint the arbitrator, they will itself communicate between each other, everything will be done by themselves only. Here they have greater flexibility. Since the parties are doing all the work, they can do it in a greater flexible manner, they can decide how it should be done. But when you go to an institution, the institution will have the own rules that you have to follow. Here you will have greater flexibility. Now, features we can see one by one. Selection of arbitrator. The parties will by themselves they can choose the arbitrators here. The parties can select a single arbitrator or a panel of arbitrators. They can decide it on their mutual consent. Second one, procedural rules. The parties will be only will be determining the procedural rules applicable for the arbitration. They will have the flexibility. What will be the procedure? They will itself decide. And then administration. Here the parties only will need to do the administrative task. What are the administrative tasks in the arbitration? Hearing date, when the hearing will be happening, document exchange. When one party gives document, we have to verify that it reaches the arbitrator, it reaches the other party. That also we have to verify. And then coordinating communication. If one party gives a message to the arbitrator, it should be clear and proper. That also we should verify. This is all done by the parties itself in the arbitration, ad hoc arbitration. In this, main things only all the work is done by the parties. And then flexibility. Since all the work they are doing, they can do it flexibly. And then the cost. Here they only doing all the work. They did not pay fees to the arbitration institution. So it will be very cost effective. And enforceability. The arbitral award is same as the arbitral institution award. If you appoint an arbitral institution also, they will give an award. You itself do all the work, then also they will give an award. There is no difference in the legal status between these two awards. Now, if the award it will be given in arbitration, it will be governed by the law given in the country. There will be national laws, there will be international laws, everything will govern the arbitral award. Now, the next point is expertise of the arbitrator. Since the parties itself appointing the arbitrator, they can decide the expertise. For arbitrator, what he should know, whether he should know related to software or he should be expert in law or that field they can decide, and they can appoint a proper arbitrator. It will be a tailored and specialized approach. Only the parties know in detail about their case. Now they can appoint the arbitrator suitable according to their wish. Level of confidentiality. Only the parties and the arbitrator are involved in the arbitration. There will be a greater level of confidentiality. The summary is that they have a high degree of control and flexibility. It will be suitable for parties who are familiar with the arbitration procedures. There will be parties who have many problems with many clients. Now they will be doing arbitration in many times. So they will be very well familiar with the arbitration procedure. What we should do in our arbitration, what is the first step, what is the second step, how should the award be made, everything the parties know. Now they can do the arbitration themselves. If you do not know the arbitration procedure, then you have to appoint the institution. Otherwise, if you know the procedure, ad hoc arbitration is enough for you. Next type of arbitration which we are going to see is institutional arbitration. In this, we will appoint an arbitral institution. They will do all the administrative work as we saw already, and they will facilitate the communication. They will help to appoint the arbitrator. Many things will be done by the arbitral institution. Here, the features will be given here. The administration, it will be done by the institution, and procedural rules. Since they are an institution, they will have their own set of rules that the parties along with the arbitrator, everyone should be following that rules only. Appointment of arbitrator. The institution will help in the appointment of arbitrator. They will give a list or they will have a specific appointment mechanism. By that procedure, they will appoint the arbitrator. Support of the institution. The institution will help in case management and the administrative tasks like scheduling hearing, managing communication. In that, the institution will help you. And then impartiality. Since there is an institution, both the parties will have to follow the rules of the institution. Both will be given on an equal level playing field. So even if the party knows about the arbitration procedure and the other party does not know about arbitration procedure, there will be no advantage. Both the parties will have to follow the rules of the institution. Now, they will choose the institutional arbitration for the credibility. They will be impartial. They will guide the person who do not know the procedure, so that there will be no advantage for the person who already knows the procedure. This they will ensure in the arbitral institution. Now, cost and fees. Since you are choosing an arbitration institution, you have to pay fees to the institution. This will be a little bit higher when compared to the ad hoc arbitration. In ad hoc arbitration, you are doing all the work. No need to pay fees to anybody. The preservation of confidentiality. Here, the arbitration institution, they will have rules. How they should maintain the confidentiality. What will do if they breach the confidentiality. Like that, they will have rules. This is important for parties who wish to keep the details private. If you want to keep the details private, you can go to the institution. They will have a procedural framework to keep the details in a confidential manner. Here, institutional arbitration has a structured and efficient dispute resolution approach. It will be done with the support of an institution. It will contribute to reliability, efficiency. The same words are repeated everywhere. You can read this one more time if you want. Here, after completing two types, ad hoc and institutional, they have given a difference. The same point they have given in a tabular column. You can read this if you require. I would recommend not reading this. It is the same thing as given in the above provisions. And then the next type of arbitration is domestic arbitration. What is a domestic arbitration? We already saw in the basics of arbitration chapter. This is a domestic arbitration which occurs in India. The place of arbitration is in India. Then it will be a domestic arbitration. The next type of arbitration we are going to see is domestic arbitration. Here it is given that the domestic arbitration denotes an arbitration which occurs in India. In this arbitration, both the parties must be Indian. As we saw already, there will be two Indian parties. Only then the arbitration will be a domestic arbitration. But here they are also giving that arbitration which occurs in India. How they are deciding that arbitration which occurs in India is a domestic arbitration? It is not given in the express law, but they have understood it by reading the section 2 subsection 2 along with section 2 subsection 7. By reading this together, they are telling that domestic arbitration means an arbitration where the arbitral proceedings must be held in India and according to the Indian law. Two Indian parties, it should be held in India. Indian law should be applied. Like that they are telling. Now, what are the features of domestic arbitration? Rules and regulation. Rules and regulation will be governed by the Indian laws. If it is happening in India, only Indian law will be applicable. Indian arbitration laws will be applicable. Next thing is flexibility in procedure. Since it is happening within the borders of the country, the parties itself can determine the procedure. They can choose the arbitrator, establish the agreement, define the scope of arbitration. Everything the parties itself can do. Valid arbitration agreement is very important for domestic arbitration. The agreement should specify the intent to resolve disputes through arbitration. The agreement should be giving that when we have a dispute, we will resolve through arbitration. We will not go to traditional litigation. Litigation means court case. You should be going to court in case of traditional litigation, but the agreement should specify that you are going to arbitration. The next point is selection of arbitrator. In a domestic arbitration, the parties can select their arbitrators. Number of arbitrators, qualification, method of appointment, everything can be determined by the parties. It will be given in the arbitration agreement. Powers of the tribunal. What are the powers which are given with the arbitral tribunal? It is given in the Indian law. They can make decision on procedural matter, which procedure they can determine. They can consider the evidence. They will give a final award. This is the powers of the tribunal given under Indian law. Awards. Domestic awards are generally enforceable in the same way as court judgment. If a court give a judgment, how that judgment will be implemented? In the same way, the arbitral award will also be implemented. Confidentiality. Confidentiality is a common feature. Under domestic arbitration, it will be very confidential. There are provisions for confidentiality in the Indian law. Cost effectiveness. Domestic arbitration is chose for cost effectiveness and efficiency. When compared to court proceedings, it will be very effective. When we are going to court, it will take many years and it will be very expensive. But arbitration, it is very cheap when compared to court proceedings. Expertise of the arbitrator. The parties, as we said already, in the above types of arbitration, they itself can select the arbitrator who has the expertise in the specific field. And then, it is an informal process. Domestic arbitration proceedings are less formal when compared to court proceedings. These are the points which are given in the domestic arbitration. We already understood these by seeing the Arbitration Act, but this is given in this chapter, so I am reading this once again. The next type of arbitration is international arbitration. As we saw in the Arbitration Act, international commercial arbitration where at least one of the parties is outside India. At least one party is from outside India. This is itself given here. Where at least one of the parties is involved is domiciled outside India, or the subject matter is related to place outside, then the arbitration is an international arbitration. It is a method of resolving dispute between parties from different countries or involving cross-border transaction. Either there are different countries and parties involved and cross-border transaction involved, then it is an international arbitration. The features are parties. Parties will be from different countries or there will be cross-border transactions. They will require a neutral forum for finding the solution. Arbitration agreement is also required here. Same as domestic arbitration, we need a valid arbitration agreement. Now, in that arbitration agreement, it should be written as we will resolve through arbitration. And then impartial forum. We need a neutral forum so that we can avoid the bias. We can avoid a favorable party. Like that, the impartiality will be maintained associated with the national court. If there are two parties, one party is from USA, other party is from India. If the arbitration takes place in India, there may be a chance that the Indian court will be deciding in favor of India. They will give interim measure and many things they will do in favor of Indian person. So, for avoiding this, they can select a neutral forum. International arbitration allows parties to choose the governing law. Under section 28 of the Arbitration Act, it is given that under international commercial arbitration, the parties can designate the law. This is given under section number 28. So, by designation, the parties can choose the law according to which they can conduct the arbitration. International arbitration, they can conduct in ad hoc or institutional method. They can appoint the arbitrator themselves, they can do the administrative work themselves, or they can appoint an institution to do all this work. Next point is selection of arbitrator. Here in the international arbitration, parties can select the arbitrator themselves. Now they are chosen for their familiarity with diverse legal systems and cultural backgrounds. Now we can select the arbitrator which has a cultural background, different cultural background. For example, International Chamber for Commerce, they have very experienced lawyers who have saw many cases in international arbitration. They have a diverse legal system knowledge. They have diverse cultural background. You can select them. Like that, they are saying confidentiality. Here also same confidentiality related provisions are given. Cultural sensitivity. Since the parties are from different cultural background or different country, we have to give importance to the culture. And witness of the expert. In the international arbitration, if it is related to a specific technical area, the arbitrator can appoint expert to give opinion and give some explanation on the technical or industry specific issues. The next thing is limited grounds for challenge. When it is an international award, you cannot challenge it on many grounds. You have only limited grounds for challenge. Only for certain reasons, you can challenge the arbitration award or arbitrator. Like that, you can challenge only for certain reasons. So it will lead to a more conclusive resolution. In one way or the other, you will definitely get a conclusion. It is cost effective. It offers a potentially cost effective alternative to litigation. Same, when compared to court, it is very cost effective. Now, as the same, we have given domestic arbitration, international arbitration difference. This you can read it by yourselves. The next thing is contractual arbitration. In this, what is the main thing is, before the dispute arises, when signing the main contract itself, they will also have an arbitration clause. This is the contractual arbitration. By this, what they are saying is, while saying the main contract itself, you have an arbitration contract also. That is why the name is contractual arbitration. Here, the parties choose to incorporate an arbitration clause. This is called contractual arbitration. The features are arbitration clause. It will be included in the arbitration agreement. Freedom of the parties. Parties can decide the arbitration clause according to their wish. Selection of arbitrator. It will be done as per the wish of the parties. Rules of arbitration. They can choose ad hoc or they can also use an arbitral institution. Confidentiality. It will be confidential. Enforceability of arbitration awards. For the arbitration award to be enforced, it will be same way as the judgment of the court. And then speedy resolution. Arbitration clause is added to resolve through arbitration. When compared to court, you can solve it in a quicker manner. Procedural flexibility. You can decide the procedure by yourself. All these are repeated points. If you want, you can pause the video and read it. Next type of arbitration is statutory arbitration. In statutory arbitration, it is imposed by the operation of law. The parties are not choosing it by themselves, but the law is imposing the arbitration on the parties. For example, in the Indian Trust Act, Section 43C provides to deal the dispute to arbitration. Under Section 43C, it is given that that particular dispute should be solved only by arbitration. Now, the parties need not enter an arbitration agreement, but the parties have no option but to abide by the law of the land. They have to compulsorily follow arbitration. This is called a statutory arbitration. Here, the consent of the parties is not required. But in the earlier types of arbitration, we need the consent of the parties. The parties need to give consent by making the arbitration agreement. Only then we can make the arbitration. The features of the statutory arbitration are, this is based on specific laws. These laws determine the procedure, rules, everything will be determined by the law. Requirement for the valid agreement. They are not entering into an agreement. The law is imposing the agreement on them. It is decided by the statutory provisions. It may include the language required, form of notice, etc. Everything will be given in the law. Types of disputes. Statutory provisions determine the type of disputes to which these provisions will apply. Upon which the statutory arbitration will apply, that will be decided by the law. Selection of the arbitrator. Statutory laws may determine the required qualification for the arbitrator. In case of statutory arbitration, the qualification of the arbitrator will be given in the law. It may also give the formal mechanism to select the arbitrator. There will be a separate mechanism for appointing the arbitrators. Under the law itself, it will be given. Requirement of specific expertise. In some cases, statutory arbitration may provide special expertise. For example, there will be requirement in the law. For specific cases, the arbitrator should have this much qualification. He should have expertise in these fields. Like that, the requirement will be given in law. Confidentiality. The confidentiality provisions will also be given in the law. It will help to maintain the confidentiality. Cost effective. Statutory arbitration are designed to provide a cost effective and alternative dispute resolution to court litigation. When you compare the cost to court, the court litigation will have more cost. But when you take the statutory arbitration, there will be less cost involved. Here we have given a difference between contractual arbitration and statutory arbitration. You can read this if you want. The next type of arbitration is fast track arbitration. Section 29B of the Arbitration and Conciliation Act provides for fast track arbitration. It is a time bound device. The maximum time limit is 6 months, which is given under Section 29B uses one more very important section which you have to remember. They may ask in exams under what section the fast track arbitration is given. Like that they can ask the questions. The features of the arbitration are accelerated process. Since the time limit is 6 months, the process will be very fast. Limited requirement of documents. Here the decision will be taken not to studying the document line by line. They will focus on the main conclusion of the document and the evidence, whether it is proper or not. They will see it in a holistic manner and it will be decided faster. Simple procedure. There will be a simple procedure. It will have a more focused discovery process and shorter hearings. Within a short number of hearings, the award will be given. Limited number of hearings, and the number and duration of hearings is also limited. The process involves witness testimony and expert presentation to essential matter. When you want an expert presentation, you can order an expert presentation. Selection of arbitrator. Priorities are always given to individual with experience in handling expedited cases. For example, you have two arbitrators. First arbitrator will always solve the cases within 6 months. In all the cases which he have solved in the past, he have decided the matter within 6 months. And we have a second arbitrator. He will take up to 12 months for many cases. Now, which arbitrator we will choose for fast track arbitration? Definitely we will choose the first arbitrator, because we have to complete it within 6 months. And short timing process. The timeline is compressed. Under section 29A, normal arbitration will have up to 12 months. You can also extend it by 6 months. But under section 29B fast track, the total time limit itself is 6 months. Cost effective. Since it is time bound and within a short period of time it will be completed, the overall cost will be reduced. This will be achieved by combination of limited discovery, shorter timeline. This all will contribute to for the cost effectiveness of the fast track procedure. Arbitration awards are final and binding. Same as 29A, 29B fast track procedure awards are also final and binding. There is no difference in the legal status of the award. Flexibility. For an accelerated framework, there is still some flexibility. Even the framework is accelerated, you have to complete within 6 months. Still certain things can be decided by the parties. Specific procedures can be decided by the parties. The next type of arbitration is foreign arbitration. When the seat of the arbitration is outside India, it is a foreign arbitration, and the arbitral award which you are getting from foreign arbitration, it will be a foreign award. The simple thing is, seat is outside India, that is the proceedings conducted outside India. It is a foreign arbitration, foreign award will be given. That's all. These are the types of the arbitral proceedings. Now we are going to types of arbitral award. In these types of arbitral proceedings, what award will be given? That is given into the next part of the chapter. Ad hoc arbitral awards. When you conduct an ad hoc arbitration, that is the parties itself will do the administrative work, appointment of arbitrator and all, you will get an ad hoc arbitral award. The domestic arbitral award. Under a domestic arbitration, you will get a domestic arbitral award. Here the main point is dispute will be solved within the borders of a single country. Now, the arbitration process is subject to the laws and regulation of a specific country. Only one country laws will be applicable. But in case of international arbitration, cross-border transaction and parties from different country will be involved. So, multiple laws will be followed. In domestic arbitration, only one country law will be followed. And for enforcement of the domestic arbitral award, there will be provision given in the domestic legal system. According to the country's law, you have to implement the arbitral award. The next point is international commercial award. This will be coming out of an international commercial arbitration where at least one party is from outside India. This involves parties from different countries. It will be related to international transaction. It will be used for solving disputes from international transactions. Instead of resorting to national courts, parties often choose arbitration as a method of resolving their dispute, and the resulting award are called international commercial awards. Now the features given are applicable law. Since it is an international award, it will be based on more than one country law. The parties usually agree on the governing law. According to section 28, in an international commercial arbitration, the parties can choose the law according to which the arbitration will take place. This is given here. Arbitration agreement. Here also in the main contract, you should involve an arbitration agreement. And then appointment of arbitrator. In an international commercial arbitration, they will appoint the arbitrator by choosing an institution. This is a very important step. Since it is an international arbitration, they have to appoint a proper arbitrator. He should be independent, impartial. He should have the expertise in the field. Now they will go to arbitral institution for selecting proper arbitrators. Enforcement. Now it is an international award, so the recognition and enforcement will be as per the international conventions like the New York Convention. Now the New York Convention will apply over 160 countries. In this 160 countries, if you make an award in any of these countries, it will be applied as per the New York Convention. So there will be a streamlined enforcement procedure. In all the 160 countries, if you get an award, the enforcement procedure will be the same. Arbitral procedural rules. Here you can have a flexibility in the procedural matters. The parties can decide the procedural specific matters by themselves. Cost and time effectiveness. It will be costlier when compared to domestic arbitration, but it will be cheaper when compared to court. When you go to court, there will be more cost involved. But when you go to international arbitration, the cost will be less. Confidentiality. Here also there will be a confidential provision. Now let's see about enforcement of foreign awards. New York Convention awards. The first section we are going to see under the chapter 1 is section 44 definition. This is the definition of foreign award. This chapter is about the enforcement of foreign awards. So we need to know what is a foreign award first of all. This we saw already while studying part 1 arbitration of the Arbitration Act. We are going to see it once again. It is an award arising out of legal relationship, whether contractual or not. It is considered as commercial under the law in force in India. Made on or after 11th October 1960. This is not so important, but this is a basic provision. Award should be arising out of legal relationship. It should not be arising out of illegal relationship. If it is an illegal relationship, you cannot make an arbitral award for that. And it should be considered commercial under the law in force in India. There are laws like there are laws in our country like the Commercial Courts Act. Like that there will be laws, and under that law the issue should be considered as a commercial issue. And this date you need not remember. And here is the substance of the definition. It should be in pursuance of an agreement to which the convention in the first schedule applies. The agreement here they are referring to the arbitration agreement. You should have an arbitration agreement, and following that you should have you should have conducted an arbitration, and from that arbitration you should get an award. That is the foreign award. And for that agreement, the convention in the first schedule should apply. New York Convention should apply to the agreement. Then the next point is in a territory. The award should be made in a territory outside India. That outside India territory should be applicable. The convention should be applicable to that outside territory. How you will know whether the convention applies or not? It will be notified by the central government in the official gazette. There will be a notification. In that they will give the list. For this all countries, the New York Convention will apply. In that list, the outside territory where the award is made, that country should be there. In simple words, to summarize, we can understand that foreign award is an award where the seat of arbitration is outside India. That is the place of arbitration. In the Arbitration Act, the word place is used wherever they have to refer to the seat of arbitration. That is, the place of arbitration should be outside India. Application of foreign laws. The award should be made according to the foreign laws. Nationality of the parties is not considered while determining whether it is a foreign award or not. And the country in which the award is made, the convention, New York Convention, should apply. First thing, the place of arbitration should be outside India. Second one, it should be done according to the foreign law. Third one, the outside country should be a party to the convention. That is, the New York Convention should apply. Here, one thing we should not see, that is the nationality of the parties. This is decided in the case law PISL Wind Solutions versus GE Power Conversion. In this case, the Supreme Court made a judgment that even two Indian parties, they can make a foreign award by selecting a foreign seat of arbitration. They can apply foreign law and they can get an award. For that, even the outside India country, the convention should apply. If all these conditions are fulfilled, even if there are two Indian parties, it will be considered a foreign award. This is given under this case law. I will upload a detailed video on this case law. And the next section is section number 45. Power of judicial authority to refer the parties to arbitration. There is a judicial authority. Court will come under judicial authority, and there are many other judicial authorities. When you are going to a judicial authority for a case, the judicial authority shall refer the parties to arbitration where there is an arbitration agreement, and a request from parties is also received. Like we saw an example in the first video of this Arbitration Act, we saw there are two parties, party 1 and party 2. They both have a dispute and they also have an arbitration agreement. But instead of going to arbitration, party 2 directly goes to court. Now, we already saw that in the first argument, party 1 should say that we have the arbitration agreement, we will go to arbitration. This we saw in a section in the part 1. Same like that, here there is an arbitration agreement under section 44. Here under section 44 we have an arbitration agreement reference. This agreement should be existing between the parties, and then the request should be from the parties to go to arbitration. The party, one party or any party claiming under him, he should make a request to the judicial authority that we will be going under arbitration. Do not take this case under court. Like that there should be request. Here the judicial authority shall refer the parties to the arbitration. Here there is a compulsion to the court to refer the parties to arbitration. First condition, arbitration agreement. Second condition, request. If these two exist, the judicial authority should compulsorily refer the parties to the arbitration. In certain cases, he need not refer to the arbitration, where the arbitration agreement is null, void, inoperative, or the arbitration is incapable of being performed. In these cases, you need not refer to arbitration. First thing is, there should be an arbitration agreement. Second one, there should be request. You can refer to arbitration. In these cases, you cannot refer to arbitration. The next section is section number 46. When a foreign award will be binding. Enforceable foreign awards will be binding for all purposes, defense, set-off, any other legal proceedings. The foreign award, if it is proper, if it is a foreign award under section 44, it can be binding for all purposes. You can use that award for defense, you can use that award for set-off, you can use that in any other legal proceeding also. It will be binding. Section 47, evidence. Party seeking enforcement. If the foreign award is made in a foreign country, the assets for the party situated in the India will be involved in the arbitration. So you have to implement the award and make the implementation of the award and recover the assets or make the payment. Like that you should implement it in India. For implementing, you have to come under section 47. For implementing, you should provide evidence to the court that this is a foreign award. What are all the evidence they are asking? Original award or duly certified copy. And then original arbitration agreement or duly certified copy. Next is that such evidence to prove that it is a foreign award. There is no alternative. All these things should be present at the time of application or during the court proceedings. But you should give all the three of this to enforce the award. First thing is original award. Foreign award that they gave, that original copy you have to give. Arbitration agreement original copy also you have to give. Then additional evidence you have to give. If the court asks any additional evidence, that also you should give. Here in the Bar Act, it is given to that at the time of application you have to submit all the three things. But it is interpreted that you can also give that during the court proceedings. You need not give all the three during the start itself. You can also fulfill this condition by giving the documents after the proceedings have started. This is the evidence section. And if the award is in a foreign language, you should give an English translation. That translation should be certified by a diplomatic or consular agent. This is the agent given under the Arbitration Act. That agent should certify. They should tell that the translation is correct. You can depend on the translation. Like that they will give a certificate. That also is required. Here in the explanation it is given that you have to give it to the court. The enforcement, party seeking enforcement, you should produce the documents to the court. What is the meaning of court? Here it is given that court meaning high court. Here it is a foreign award, it is a bigger case. So the court refers to high court having original jurisdiction or appellate jurisdiction over the subject matter. The subject matter of the case is important. If the subject matter is a sale agreement or purchase agreement, there will be a high court which has jurisdiction, which has the authority to make decision on sale or purchase. On that high court will be referred where the word court is given. The next point is the foreign award given after the commencement of the act can be enforced only under this act. Even after the commencement, some foreign award is coming. Even if arbitral proceedings commenced before an act. This act enforced on certain date. For example, we can keep it as 1st April. Any proceedings, arbitral proceedings started before this date and the award came after this date, or the award came also before this date. That award should be enforced only under this act. You cannot go to any other previous act. Foreign award given after the commencement of this act can be enforced only under this act, even if the arbitral proceedings commenced before the act. For example, we can take a date 1/4/22. We can assume that this arbitration act commenced on this date. Any award, any foreign award given after this date should only be enforced under this act. You should not go to the previous act. Even if the arbitral proceedings for such arbitration award commenced before the act. For example, we can take an arbitral proceedings, it commenced on 1st March 22, before the commencement of the act, but the foreign award came out only on 2nd April 22. You should consider the date of the award, 2nd April 22. It is given after the date of the commencement of the act. Then this award should be enforced only under this act. You cannot say that I will enforce the award under previous law because the arbitration proceedings started before the act. Like that you cannot say. Any award given after the commencement of the act should be enforced only under this act. This is an important point. The next section is section number 48, conditions for enforcement of foreign award. Under what all the grounds the foreign award cannot be enforced, like that the conditions are given here. For example, when there is an arbitral award, it will be favorable to one party and unfavorable to another party. Now, the unfavorable party, the party to whom the arbitral award is unfavorable, he can make a request to the court for refusing the enforcement. He will tell to the court that do not implement the award. Like that he will tell. For that, he should state some reasons. What are the reasons? That thing is given here. Subsection 1 gives some reasons where the proof should be furnished by the party. The unfavorable party should furnish the proof. For what thing he should furnish the proof? That parties was under incapacity, agreement was not valid, or agreement was contrary to the foreign law. Since it is a foreign award, it will be based on a foreign law. There will be an arbitration act under the foreign law. If the arbitration agreement is against the arbitration act of the foreign law, then this is a reason. If the party was under incapacity, this is also one reason. then agreement was not valid under foreign law. That also is a reason. For these reasons, if the unfavorable party furnish the proof, the court can refuse the enforcement. Court will not implement the foreign award. The second thing is the unfavorable party can tell that I was not given proper notice of arbitrator appointment or arbitral proceedings. I was not given proper notice. I did not know who was the arbitrator. I did not know when the proceedings were held. I was not given proper notice. That reason he can tell. And then otherwise he was unable to present his case. Due to any other reason, I was unable to present my argument during the arbitration. So this is a one-sided arbitration award. So you should not implement it. Like that also the unfavorable party might say. For saying all this, he should give the proof. The most important thing is proof. 48(1)(c). The award contains decisions on matters beyond the scope of arbitration. For example, when you refer to arbitration, you will give certain things. These are all the matters on which we need a decision. For that decision, the arbitrator will give the decision. This will be contained in the arbitral award. For example, in an arbitral award, there is a decision. That thing was not asked to arbitration. That question was not even asked to arbitration. But the arbitral tribunal gave a decision on that matter. So, this is a thing beyond the scope of the arbitration. Now, this also the unfavorable party can prove to the court, and after such proof, the court will not implement the foreign award. The next thing is composition of arbitral authority. The composition of the arbitral authority is not in accordance with the agreement. In the arbitration agreement, it is given that there should be one chartered accountant, one company secretary, and one cost and management accountant. These three persons should be the arbitrator. Like that, if it is given in the arbitration agreement and the arbitration tribunal, actually there were not one company secretary and one cost and management accountant. Only one chartered accountant was the arbitrator. In this case, the arbitral authority composition is not in accordance with the agreement. This is a reason for refusing the enforcement of award. And in the foreign law itself, there is a composition, like there should be this much members, this much women should be there, like that there is a composition. If that also not followed, then that also will be a reason for refusing the enforcement. If you have an agreement, it should be in accordance with the agreement. Where there is no agreement, it should be in accordance with the foreign law. What should be in accordance? It should be the composition. The next thing is, the award is not binding or suspended or set aside by a competent authority under foreign law. The foreign law under which the award is made, under foreign law, a competent authority like a judicial authority has suspended the award or set aside the award, or there is some proceeding pending relating to the bindingness of the award. If there is a question with respect to the bindingness of the award, whether the award is binding or not, that we do not know. There is a proceeding or some kind of uncertainty is there. Then also we cannot enforce the foreign award. In short, the first thing we are saying is the party should furnish the proof. Who should furnish the proof? The unfavorable party. For delaying, for stopping the enforcement, for not implementing the award, he should give proof. For what and all? That he was under incapacity, or the agreement was not valid, or the agreement was opposite to the foreign law. And he can also tell that I was not given proper notice of arbitrator appointment and proceedings, or he was unable to present the case, or the award contains decision on matters beyond the scope of arbitration. He can also say that the composition of the arbitral authority was not proper. He can also say that the bindingness of the award, there is an uncertainty. Like that he can say, and say the court that do not implement this award. Like that he will tell to the court. The court will examine the proof and make the decision whether they should implement it or not. The next thing is section 48 subsection 2. Enforcement is also refused where the court finds that under the above section the party has to furnish the proof. Here the court itself, suo moto, they can make a decision to not enforce the award. What are all the reasons for court to find? Subject matter not capable of settlement by arbitration. For example, there is a murder case. You are settling it by arbitration and coming with a foreign award. This dispute is not capable of settlement by arbitration. In this case, the court will not enforce the award. Enforcement is contrary to the public policy of India. What is public policy? How you will find whether it is opposite to the public policy or not? For that, there are two explanations. Explanation 1. Conflict with public policy when these three situations are there, then we can say that the award is contrary to public policy. Making of award by fraud or corruption. There is fraud or corruption in making of the award. The award is in contravention of the fundamental policy of the Indian law. And the award is against the basic morality and justice. Basic justice itself is not there in that award. In these cases, we can say that the award is in conflict with the public policy. Now, for checking whether the fundamental policy is opposite or not, we should not go into a review of the merit of the dispute. What is the merit of the dispute? While deciding whether it is opposite to the fundamental policy or not, you should look only at the award. You should not go into the details of the case. Who started the problem first? What are the proceedings happened? That details you should not check. Only the award you should check, and you can decide whether it is opposite to the fundamental policy or not. This is given under section 48 subsection 2, whether the subject matter not capable of arbitration or it is contrary to the public policy. This is given under section 48. The next point is court can adjourn the enforcement. They can postpone the enforcement. On what reasons they can postpone? Application for setting aside or suspension of award made to competent authority. In the above section we saw that a competent authority under foreign law, if they set aside the award or suspend the award, we cannot enforce the foreign award in India. So for suspending the award under foreign law, if you have filed an application, that application is still pending, but the competent authority will make the decision on the application later. Now here there is a problem relating to the suspension of the award. We do not know whether the award will be suspended or not. In this case, we have to come to the court and say that adjourn the enforcement. I have filed an application for setting aside of the award. If you say like that, the court will adjourn the enforcement. And when you adjourn the enforcement, the favorable party, the party to whom the arbitral award is in favor, they will get a doubt or they will get an uncertainty whether they will get the amount or not, whether they will be able to recover the amount or not. In that case, the favorable party will make an application to the court, and the court will say that unfavorable party should give suitable security. For example, the unfavorable party should pay 1 lakh rupees to the favorable party. For example, this is the arbitral award. For enforcing this, we are coming to the Indian court, but the unfavorable party make an application to adjourn the enforcement. Now the enforcement is adjourned. The favorable party is very scared that whether he will get that 1 lakh or not. Now what the favorable party must do is that he must make an application for suitable security. Now for this application, what the court will do is that the court will ask the unfavorable party to make a deposit of rupees 1 lakh. This deposit will be made with the court. If the deposit is made, the favorable party will have a certainty, or he will have a hope that if the case comes in favor of favorable party, then the 1 lakh will be received by the favorable party. There is no uncertainty regarding the recovery of the amount. This is the reason for security. We already saw this in part 1 of the arbitration also, why we are asking the security. These are the grounds for which you can stop the implementation of the award. The next section is enforcement of foreign award, section number 49. If the court is satisfied that the award is enforceable, the award will be deemed to be a decree of the court. The court is thinking that the award is a proper award, it can be enforced. Now that award will be deemed to be a decree of the court. In the manner how a court order will be implemented, in the same manner the award will also be implemented. Section 50, appealable orders. Under this part, there are certain orders against which you can go to an appeal. What are those orders? Refer to arbitration under section 45. You are coming to refer to arbitration under section 45, and the court is telling, I will not refer you to arbitration. Against this decision, you can go to an appeal. And enforcement of a foreign award. You are coming to enforce a foreign award under section 48. You are telling that the award is not proper, but the court is telling that this is a proper award. I will implement this award. Like that the court is telling. Now you can go to an appeal against this decision. For this decision, you can go only one appeal. No second appeal shall lie. But this does not harm any rights. This does not take away any right to appeal to Supreme Court under the Indian Constitution. From this section, you cannot go for appeal under the Arbitration Act. But under Constitution, Indian Constitution, every citizen is given certain rights to appeal against any decision. That right is not being taken away by this section. The next section is section number 51, saving, not harm any rights. If this act was not enacted, some party will have some rights that is not related to this act. That rights are not affected by the implementation of this act, Arbitration Act. Then section number 52, chapter 2 will not apply. For foreign awards, where chapter 1 will apply, the chapter 2 will not apply. Either chapter 1 or chapter 2 will apply. First priority is for chapter 1. First we will check whether chapter 1 is applicable or not. If chapter 1 is applicable, we need not check chapter 2. The next thing we are going to see is the Geneva Convention awards. We saw two conventions, right? New York Convention, and the second one is Geneva Convention. New York Convention is given under chapter 1 of part 2 of the Arbitration Act. This is the chapter 2 of part 2 of the Arbitration Act. This is very similar to the New York Convention, except at some places where you have to concentrate a little bit to understand this. This is very easy. Now we can get into the chapter. The first section which we are going to see under the Geneva Convention is section number 53. In this chapter, foreign award means an arbitral award. By this, what we can understand is that for foreign award, under section 44 a definition was given, and under section 53 also a definition is being given. So section 44 definition will apply to New York Convention chapter 1. The section 53 definition will apply to Geneva Convention chapter 2. This is the thing we have to understand by this line. This is also similar to the section 44 definition. It should be an award on the differences considered as commercial, and it should be made after this date. Like that is also same as section 44. In pursuance of an agreement, here also they are mentioning the arbitration agreement. Arbitration agreement should be made, and for that the second schedule convention should apply. That is, the Geneva Convention should be applicable to the arbitration agreement. And here, this is by reading this we will be wasting time, so we can directly read the explanation. This is a not so important section. So here the According to section 53, government by notification has to declare the territories to which the Geneva Convention would be applied. Same like that, the government will declare for what are all the outside India territories the Geneva Convention will apply. If the award is made in such territory which are not the parties to Geneva Convention, Chapter 2 will not apply. If the award is made in a country where Geneva Convention will not apply, then that award cannot be enforced under Chapter 2. Now, if a foreign award will not be considered final if any proceeding in respect of validity is pending in the country. The award is being made in a foreign country, then only it is called a foreign award. If any proceeding, any court case or something like that is pending in the foreign country regarding the validity of the award, whether it is final or not, like that there is any proceeding pending. Now, that award will not be considered as a final award. We should wait for the outcome of that proceeding. Only then we can enforce it under this law. In simple words, if you want to understand this section briefly, there should be an arbitration agreement for which the Geneva Convention applies. The award should be made according to the foreign laws. It should be made in a territory outside India. For that outside India territory, the Geneva Convention should apply, and then the award should be final. There should be no proceeding pending relating to the finality of the award. These are the 4 pointers given under the section 40. These are the 4 final points given under section number 53. The next section we are going to see is section number 54, power of judicial authority to refer the parties to the arbitration. Same like that, we have some pointers here. These are the condition for the judicial authority to refer to arbitration. There should be a dispute for which section 53 applies. Okay, there should be a dispute. Second one is that there should be an arbitration agreement. Okay, the third point is there must be an application to refer to arbitration by any party. Any party to the arbitration, they should make an application that I have to solve the dispute through arbitration, do not take up the case. Like that, there should be an application to refer to arbitration. Then the judicial authority thinks that the arbitration agreement can proceed and is operative. The arbitration agreement should be operative. It cannot be invalid. Then the next point is the judicial authority must be satisfied that the arbitration is valid under section 53. First thing, there should be a dispute. Second thing, there should be an arbitration agreement. Third thing, there should be an application to refer to arbitration. Fourth thing, arbitration agreement should be operative. Fifth thing is that the arbitration should be valid under section 53. These are the 5 points. If these are satisfied, the judicial authority shall transfer the case to arbitration. One more point is that this is a notwithstanding provision. Notwithstanding anything contained in part 1 or in the Code of Civil Procedure. Now, this is a notwithstanding condition. That means that this section number 54 is superior. Only this will prevail even anything contrary is given in part 1 or Code of Civil Procedure. For example, something is given in section number 54 and something opposite is given in part 1 or Code of Civil Procedure. Now what you will follow, whether you will follow the part 1 or Civil Procedure or you will follow section number 54. Here, since it is a notwithstanding provision, you have to follow section number 54. This is the main point here. And then these are the 5 pointers which should be satisfied for referring the parties to arbitration. The next section is section number 55, foreign award when binding. When the foreign award will be binding, for what all the purpose the award will be considered binding. This is given under this section. It will be acting as a binding force upon the parties. For what all the purpose, for seeking defense, set off or any legal proceedings, you can take this award as a binding award. The next thing is evidence section. Same like New York Convention, here also we need evidence to prove that it is a foreign award. For enforcement, we have to give to the court the evidence. What are all the evidence? Original award or duly certified copy, and evidence proving that the award is final, and evidence, such other evidence as may be necessary. And where any document requiring to be produced is in a foreign language, you should give a translation. That is given here also. Original award, proof it is final, and such other extra evidence. This will allow the court will allow the party to fulfill above conditions even when during the proceedings. Even after making the application, you can fulfill the conditions. That point also is also given here. Diplomatic or consular agent should authenticate the translated copy. That point is also here. This is very much similar to the New York Convention. The next section is conditions for enforcement of foreign awards. Same like that we have saw section in the New York Convention. Here, for enforcing the foreign award, what are all the conditions to be fulfilled? The award should be in pursuance of a submission to arbitration, which is valid. There should be a valid arbitration for the award to be enforced. Subject matter should be capable of settlement by arbitration. It should not be a matter which cannot be settled by arbitration. Then, the award has been made by the arbitral tribunal, which has been constituted in the manner agreed upon by the parties. The arbitration tribunal, the composition is questioned here. The composition should be according to the agreement or according to the law. It should be in the manner agreed upon or it should be in conformity with the law. The next point is the award has become final in the country. In the foreign country, the award is final. There will be no proceeding pending regarding the finality of the award. Enforcement is not contrary to the public policy. Same like that, for checking public policy, what you will do, whether it is fraud or corruption, you will check. Then you will check the fundamental policy of Indian law. Then you will check the basic notion of morality, whether it is against all this. If any one of this is satisfied, then we can say that it is contrary to the public policy. For avoidance of doubt, whether there is a fundamental policy breach or not, for that you should not make a review on the merit of the dispute. You should not go into the details. You should check only the award. Next point is, for the first point, the party should furnish the proof, and here, even if the court is satisfied, you need not furnish any proof. For the court will itself suo motu, it will take a decision to not enforce the award. What are all the reasons? Award has been annulled in the country. That means it is cancelled. The country in which it is made, the award is cancelled. Party against whom it is sought. The unfavorable party we saw right in the New York Convention. That party was not given proper notice. He was not given sufficient time to present the case. He was under a legal incapacity. Same reasons for the unfavorable party. Award does not deal with differences contemplated or falling within the terms of the arbitration. Award contains decisions beyond the scope of the arbitration. Same like that, award contains beyond scope decision. Then also the court can refuse the enforcement of the award. Now here there is a proviso. For example, you have submitted 5 issues to arbitration and we got an arbitral award. In that only 4 decisions are covered. One problem, no decision has been given. Now in that case what the court will do is that it will postpone the enforcement of the award and it will do the necessary things which should be done. It should postpone the enforcement and grant it subject to such guarantee as the court may decide. The court will decide what to be done. Now here we have another point, subsection 3. Here what they are telling is that above we have told so many grounds. The court should identify by itself, the party should furnish the proof. Like that we have many grounds. But other than those grounds, the party, the unfavorable party, proves to the court that there is a ground other than the ground specified. For that, contesting the validity. On that ground, I can contest the validity of the award. Like that the unfavorable party is saying. Now what the court can do? It can give time to the unfavorable party to prove this to the arbitral tribunal. The tribunal which gave this award, unfavorable party has to prove the ground to the tribunal and he should get the cancellation of the award from the tribunal. After hearing the ground, the tribunal what will do? It will cancel the award. This is given under subsection 3. The simple thing is, if there is any other ground upon which you can refuse the enforcement other than this section, you should go to the tribunal and you should tell the ground. The tribunal, if it accepts it, it will give for the cancellation of the award. The next section is section number 58, enforcement of foreign award. Where the foreign award is enforceable under this chapter, it shall be deemed to be a decree of the court. Same as the New York Convention, if the award is enforceable, it will be considered as the court order. Appealable orders. An appeal shall lie from the order refusing to refer the parties to arbitration or enforce a foreign award in section 57 to the court authorized by law to hear appeals from such order. For example, if a court is not referring you to arbitration under section 54 or a court is not setting aside an award or refusing the enforcement under section 57, under these sections you can go for an appeal. For a court which is authorized to hear the appeals. No second appeal shall lie. Only one appeal you can go, but this section does not take away any right to appeal to the Supreme Court. Same as the New York Convention. This is the last section of the Geneva Convention awards, saving. Nothing in this chapter shall prejudice any rights which would have had of enforcing in India of any award or of availing himself if this chapter had not been enacted. Some parties will have certain rights before the commencement of this act. By commencement of this act, those rights are not affected. That is given in another section. This is not so important, but I am reading this once for your clarity. This is the end of the Geneva Convention. We have completed the entire New York Convention, Geneva Convention, and before that we saw the types of arbitral awards, types of arbitration, everything we saw. This chapter does not have so much weightage as the conciliation. It has a very low weightage when compared to the fundamentals chapter or the conciliation chapter. But still, if there are questions coming from this, you can easily tackle. Since the New York Convention and the Geneva Convention are very similar, you have to remember only certain conditions, either for the refusing for enforcement or for appealable orders. It is very easy to remember this. If you remember this one time, you can easily crack the questions and you can complete the test very easily. All the best for your SPOM Set C exams. I will look forward to your results. Please share your results in the comment section when you complete the exams. Thank you. Conciliation. The section-wise weightage for this chapter given in ICA is 20 to 25 marks. By seeing this weightage, you may think that this is a very tough topic or it may be difficult. So trust me, nothing is like that. It is a very easy topic, and if you concentrate a little bit, you can score all these marks very easily. You have to remember only a certain points with which you can answer most of the questions from the conciliation part. So stick to the video. You can understand the conciliation fully by the end of this video. Now let's start. First, we can see the meaning of the word conciliation. What is conciliation? As we see in arbitration, it is a method of alternative dispute resolution. This is also a method of alternative dispute resolution. Where the difference lies is the decision of the conciliation is not binding. But whereas if the arbitrator takes a decision, it is definitely binding. Generally, the decision taken in conciliation is not binding. It is the meaning is solution of disputes by discussion. There will be a conciliator. Like arbitrator in arbitration, we will have a conciliator. He will solve the dispute between two parties by discussion. It will involve a neutral third party called conciliator. It will result in an amicable settlement between parties. It will not be in a fighting manner. It will be in a compromise manner. More or less, the issue will be settled and you can go home happily. This is the main motive of conciliation. For understanding conciliation, we can take an example. For example, in a home, we have two persons. One is a brother and the other is a sister. We have a problem between these two. These two are fighting. And now for solving this fight, what will the mother do? They will hear the things. What is the argument of brother? What is the argument of sister? Like that they will hear and they will make an amicable settlement. They will not say like this. Hear the dispute and say that the sister won, the brother lost. Like that they will not say. They will result in an amicable settlement. They will compromise those two. They will pamper those two, and they will settle the dispute by discussion in an amicable way. Both the children will go happily. This is the result of conciliation. This is the same thing which is happening in conciliation also. The mother is giving the amicable settlement. Here the conciliator is giving the amicable settlement. We need not find out who won or who lost, but we have to make an amicable settlement. Now, this is the characteristics of conciliation. Conciliation is voluntary. Both the parties must come willingly. We cannot force anyone to conciliation. Both the parties must come willingly. Non-adversarial. Adversary means fighting. One versus one. In this, the outcome will be one person won, other person lost. This is done in arbitration, but in conciliation, this is non-adversarial. That we cannot say one person won or one person lost. Both the persons will solve the dispute by discussion, and both of them will be happily going home. This is the outcome of conciliation. Now, confidentiality. There are only three people, same like arbitration, party 1, party 2, and then conciliator, party 1, party 2, arbitrator. So in this also confidentiality will be maintained. Assisted procedure. Party 1 and party 2 will perform the conciliation. Conciliator will help them to find out the solution. Finality of the settlement. In this there is a part. Like in arbitration we saw section 30 for settlement. In this also we have a settlement provision. If the conciliator provides a settlement and both the parties agree and sign the settlement agreement. Now if they sign the settlement agreement, it will be final and binding. But if they do not sign the settlement agreement, the conciliation outcome is not binding. This we will be seeing in the later part of the chapter. The next thing is conciliation is in India. According to which law conciliation is happening? In India, Part 3 of the Arbitration and Conciliation Act will apply to conciliation, and Code of Civil Procedure Section 89 will also apply. Here we will be seeing only about Part 3 of the Arbitration Act. It contains section number 61 to 81. Next we can see about section 61, application and scope. The section 61, which it is telling the application of the part which is regarding conciliation. This part applies to conciliation of disputes out of legal relationship, whether contractual or not. There should be a legal relationship, like a lessor lessee or buyer seller. Like that you should have a legal relationship. You should not have an illegal relationship. Whether you have a contract or not, that is secondary. Mainly you should have a legal relationship. It should not be illegal. This part will not apply where any disputes not submitted to conciliation due to any other law in force. For example, in any other law, it is given that certain disputes should not be submitted to conciliation. Then you have to follow that law, and that disputes will not come under conciliation. The main point in this section is you should have a legal relationship. Next, we can go to section 62, commencement of conciliation proceedings. When the conciliation proceedings will start, how it will be the procedure, that is given in section 62. The first step is given in subsection 1. The party initiating conciliation. There will be two parties in any conciliation, party 1 and party 2. One party will give a written invitation to the other party for conciliation. Party 1 is giving to Party 2 an invitation. We have a dispute. We can go to conciliation. Like that, an invitation is given. The second step is the conciliation will commence when the other party sends an acceptance in writing. The other party should send an acceptance. I accept to go to conciliation. Like that, the other party should give in writing. Both of it should happen in writing. This is the most important part. And if the second party accepts, the conciliation will commence on that date. If the second party sends a rejection, there will be no conciliation. And if the second party within 30 days he does not accept, he does not reply, or he does not send a rejection also, no reply from the other party. In this case, what will happen is the first party who sent the written invitation, he may elect it as a rejection, and he should send a written intimation to the other party like that. I sent a written invitation to you. I did not get any reply from you, so I am deciding this as a rejection, and for this I am giving this letter to you. I am electing it as a rejection. Like that, the first party should give a letter. In this section, what they are telling is that the first step, the first party should give a written invitation to the other party. If the second party gives acceptance, the conciliation will commence. If the other party sends rejection, there will be no conciliation. If there is no reply from the other party within 30 days, everywhere this 30 days limit is applicable. Generally, only 30 days is applicable in all the places in this act. May the other party within 30 days, if he does not get any reply, he may elect as rejection and send a written intimation. Next, we can go to section number 63, number of conciliators. In arbitration, we saw that the number of arbitrators should be only odd. It may be 3 or it may be 5. It may be odd number, but it should not be an even number. In this conciliation, generally, there should be only one conciliator. Here we are settling for an amicable settlement. If we have only one conciliator, it will be easy for the settlement. If parties agree, 2 or 3 conciliator may be permitted. Generally, one conciliator. If parties agree, 2 or 3 conciliator. Section 63, subsection 2. Jointly act in case of more than one conciliator. If one conciliator, he will take the decision accordingly. But if there are more than one conciliator, whether it will be majority or like that there is a question. The answer is they should jointly act. They should all discuss and they should act jointly. Now here, below it is given the reasons for sole conciliator. Why we should select a single conciliator? There is the reasons. Minimum complexity. Here we are going for amicable settlement. That is the compromise, but there will be a settlement overall. Here we should not have any complexity. So we need only one conciliator. Quicker solution. If there is only one conciliator, he can take the decision quickly. If there are more than one, they should discuss. They should take a decision jointly. It will take time. Less expensive. If we appoint one conciliator, definitely the cost will be low. Consistent approach. Every conciliator will have a different approach. If we have only one conciliator, he will take the dispute according to his approach and we can decide a settlement easily. Direct communication. If there is only one conciliator, you can tell to him directly anything. If there are many conciliators, you have to tell to all conciliators separately. It will be difficult. More efficient. One conciliator, there are less number of total persons involved. It will be efficient. Specific expertise. If you appoint only one conciliator, you can appoint a person with a specific expertise. For example, the issue is related to software. You can appoint a person who has a software expertise. The issue will be solved. Higher confidentiality. If the number of people involved in the conciliation is less, the confidentiality will be more. This is the logic. These reasons are not so important, but you can read it once to get a clarity. By this, you can answer some easy questions which will be coming in the exam. The next section is section 64, that one conciliator or two conciliator that we decided. Now, how to appoint these conciliator? That is given under section 64. Subject to section 64(2). Now, if there is only one conciliator, who will appoint it? Both the parties will make mutual agreement and appoint the conciliator. If there are two conciliators, one party will appoint one conciliator, other party will appoint another conciliator. This is the procedure. If there are three conciliators, one conciliator by each party, and then the third conciliator who will appoint, it will be appointed by mutual agreement of parties. The third conciliator is also called as presiding conciliator. If there is only one conciliator, mutual agreement. If there are two conciliators, each party will appoint one conciliator. If there are three conciliators, each party will appoint one conciliator, third conciliator by mutual agreement. The next section is section 64, subsection 2, assistance of institution. If you cannot appoint the conciliator by yourself, like in arbitration, you are going to arbitral institution. Like this also, you can go to an institution. The institution will have the list of conciliator. You can select from this. They can have two choices. The institution will give a list. In that list, you can choose the conciliator. Or the institution itself will see the dispute. They will select the conciliator for you. In the second case, where the institution directly appoints the conciliator, the institution should take into account these factors. Independence, whether the conciliator is independent or not, that they should verify. Impartiality, whether he will be impartial or there is any relationship and he can be partial, like that also they should verify. nationality other than that of the parties. If one party is from USA and the other party is from India, you should appoint a person other than USA or India. You can appoint, for example, a conciliator from UK. This will be impartial. If you appoint an Indian conciliator, it will be in favor of Indian party. If you appoint a USA conciliator, it will be in favor of USA party. So for avoiding this, you can avoid a UK conciliator. This is given in this proviso. Like this, the appointment procedure is given in section number 64. Now we can go to the next section. Section number 65, submission of statements to the conciliator. The parties have appointed the conciliator. Now how they will inform the dispute to the conciliator? Conciliator will request the parties to give a brief written statement. First step, he will ask a brief written statement, a short summary of the problem that is going on, general nature of the dispute, whether it is related to rent agreement or purchase agreement or any sale or any software, which general nature of the dispute is that the conciliator will ask, and the points at issue. In this dispute, what are the points in which you have to make the decision? In what questions I have to answer by making the conciliation? Like that, he will ask you the points at issue. Then, after the short summary, he will ask a further written statement. This is a very detailed manner about the facts, grounds, and the position of the party. Every party should say that these are the things that happened. I am making this contention based on these grounds. I will be taking this decision. You have to see the validity whether this is correct or not. You should help in a settlement. Like that, each party will say the facts, grounds, and the position of the party. I am in which position, that also will be given. Supporting documentary evidence. If you have any support for your claims, any documentary evidence, you can also give that to the conciliator. The next step is additional information. Even after the detailed information, if the conciliator wants any additional information, that also you can ask from the parties. The first step, he will ask the general nature and the points at issue. This will be a short summary. The further written statement, it will contain facts, grounds, and the position of the party along with the evidence. The third thing is additional information. Also send the information to the other party. When one party is sending all this information to the conciliator, he should also send this to other party also. The meaning is, whatever the documents which is received by the conciliator should be given to other party also. This is the provision given under section number 65. Next we can go to section number 66. Conciliator not bound by certain enactment. Conciliator, he is the person conducting the conciliation proceedings. He need not follow Code of Civil Procedure or Indian Evidence Act. This will eliminate the obstacles for the conciliator by relaxation. These are procedural laws. If he want to follow that procedure, it will take time and it will be very difficult. If they are given a relaxation for the conciliator, then he will be able to solve the dispute easily and quickly. The next section is section 67, role of the conciliator. What the conciliator will do in the conciliation. The parties will send the statement. Now what the conciliator will do? He will assist in an independent and impartial manner. He will be independent and impartial. Conciliator will be guided by according to which procedure or according to which morality he will take the decisions. He will make the decision based on objectivity, fairness, and justice. He will be choosing the justice. He should stand on the point of the justice and make the decision. The next thing is also consider the rights and obligations of the parties. In the contract, there will be obligations and rights to the parties. That also he should consider while making the decision. Trade usage and circumstances, including previous business practices. That also he should consider. What are the circumstances of the case? Along with that, previous business practices. For example, it is a seller and buyer. There is a payment dispute. How much payment they should give, when the payment should be paid. That is the dispute. That is the dispute given to conciliation. Here, the conciliator should take into account the previous business practice. Before this transaction, while making sales or purchase, what is the practice that was followed, when the payment will be given, how it will be decided. That also you should take into account. Here, the next point is, conciliator can conduct the proceedings in the manner he considers appropriate. He can conduct it according to his own wish, but he should take into account the circumstances, as we saw already. Wish of the party to hear oral statement. If a party says that I will say oral statement, and that conciliator may or may not allow it. Speedy settlement. The conciliator should work in a motive to give the speedy settlement. He cannot prolong the case for a very longer period. He should make a quick settlement. Next, after doing this, what the conciliator will do? He will make proposals for settlement at any stage. It need not be in writing. Reasons also not required. Once the conciliator hears the problem, he gets all the brief, detailed notice. He will learn about the brief summary of the problem. He will get the detailed information. Now, he can make a proposal for settlement. He can get both the parties in a single place and he can talk to them and make a settlement at any stage. At the beginning stage or at the end stage. At any stage, he can make a settlement. The settlement need not be in writing. It can be in oral also. And reasons are not required. Why I am making this settlement? That reason, it is not required. This is given under section 67, subsection 4. The main points given on this section is he should be independent and impartial. Who? The conciliator. He should be guided by fairness, justice and objectivity. He should also consider the rights and obligation, trade usage and previous business practices. And the conciliator can conduct in the manner he considers appropriate, take into account circumstances, oral statement, speedy settlement. He can make settlement proposal also at any stage. It need not be in writing, reasons not required. The next section is section number 68, administrative assistance. What is administrative assistance? One party is giving the statements to the conciliator. Now who will send this to other party? Who will verify whether the conciliator and the other party received the statement? These are all the administrative work. For that, the conciliator can arrange an institution or some person. He can appoint a person for verifying whether the statement reached the other party, whether the date of the meeting is properly conveyed to the other party. These and all, he may appoint an institution or a person. The next section is section number 69, communication between the conciliator and parties. Parties and conciliator, how they will communicate by statement and how it will be procedure, that it is given in section 69. Conciliator may invite the parties to meet him. The parties can meet the conciliator in person. For that, there should be an invitation. That invitation may be in oral or writing. The conciliator can meet the parties separately. Party 1 and party 2 he can meet separately. First he will meet party 1, then he will meet party 2. It may be like that, or together. Both the parties will be in a place and conciliator will go and meet them. Then the parties can select the location for the meeting, where the meeting should happen. The parties will select the location, but if the parties do not select, then the place will be determined by the conciliator. How the conciliator will determine the place? After consultation with the parties. He will one more time, he will ask the parties where we can keep the meeting, like that he will ask. And then he should also consider the circumstances. He should also take the situation, what is happening, where we can keep, if we keep at this place, whether there will be any problem, like that also he should consider. The next section is section number 70, disclosure of information. If one party tells certain information to the conciliator, whether the conciliator can tell it to the other party or not, that is the question here. One party discloses information to the conciliator, and the conciliator, what he should do is that he should tell the substance of the information to the other party. Like this, the first party has told me all these reasons and the problems. What are you telling about this? Like that he should tell the substance of the information so as to get an explanation from the other party. Only if the other party knows the problem, he can give a proper explanation. For that, the problem conveyed by one party to the conciliator, he should tell the substance of the information to the other party. And if one party discloses information and informs the conciliator to keep it confidential, the party is telling the conciliator, this is a very important thing, do not tell it to the other party, keep it confidential. If the party informs conciliator like this, the conciliator should not inform to the other party. Generally, he can tell the substance of the information. If the confidential thing is given, he cannot inform this. The next section we are going to see is section number 73, settlement agreement. Like we saw in arbitration, section 30, settlement. In this we have section number 73. Certain section numbers you have to remember it by heart. This is one of the section numbers. Section number 73 is for settlement. In arbitration, section number 30 is for settlement. Now, conciliator finds that there is a possible settlement. After hearing the circumstances, after making many meetings with the parties, he is seeing that there is a settlement which is possible between the parties. Now, what he will do is he will formulate a settlement agreement. Like that party 1 will do this and all, party 2 will do this and all, this much amount will be paid, this will be paid within this time limit. Like that everything he will write in a settlement agreement. And this agreement he will show to the parties. And the parties will make observation. This thing is correct, this thing is wrong. We can change the venue of the meeting. The time limit must be increased. Like that, the parties will give recommendation. That is called observation in this section. And after collecting the recommendation, the agreement will be reformulated. After making all the changes, the agreement will be prepared once again. Now, after this agreement is prepared, it is called the settlement agreement. This is called the settlement agreement. If the parties reach the settlement agreement, under the above section, if they find the agreement, they have prepared it and finalized it, then they have to draw up a written agreement. The conciliator may associate the parties' request. By writing all the things, they should make a final agreement. This agreement, either it can be prepared by the parties itself, or if the parties could not prepare by themselves, they can ask the help of the conciliator to prepare the agreement. Now, this agreement is prepared and finalized. The next step is signing the agreement. Both the parties will be signing the agreement. After the signing, whether they can go against the agreement, like that there is a question. The agreement will be final and binding on the parties. Like I said earlier, generally the decision under conciliation, it is not binding. But in this case, where there is a settlement agreement, both the parties agreed and signed the agreement, then it is a binding decision and a final decision. Where there is no settlement agreement, it is not binding. If the agreement is signed, then it is a binding decision. Meaning the parties cannot go against the agreement. Now, the next point is conciliator shall authenticate the agreement. He will make a seal or he will make a signature, like that he will authenticate the agreement. After this step, the agreement will be very authentic. It will be signed by, it have the sign of conciliator along with the parties. It have the sign of all the conciliator. Now, it will be an authentic agreement. Furnish a copy to each party. After authentifying the agreement, he should send the copy to each party. Successful conciliation, when it is happening, is when the settlement agreement is signed and comes into existence. The conciliation is successful only when there is a settlement agreement signed. The main points in this section is section number 73, the number you have to remember, that is the one important thing. The conciliator will find a possible settlement, then he will prepare a settlement agreement and they will collect recommendation from the party, and then after incorporating the recommendation, they will prepare a final agreement. After preparing the final agreement, it will be written either by the party themselves or the conciliator may help in preparing the agreement. Then the agreement will be signed. After signing, it will be final and binding on the parties. And then the conciliator will authenticate the agreement. After authenticating, one copy will be sent to each party. Only when the settlement agreement is signed, it is a successful conciliation. The next section we are going to see is section number 74, status and effect of the settlement agreement. The settlement agreement is signed. What is the legal status of that agreement? It will be in the same status as an arbitral award and section 30 settlement. As I saw earlier, both are similar. Section number 73 settlement and section number 30 settlement, both are similar. The settlement agreement will be treated as an arbitral award and section 30 settlement. Section number 76, termination of proceedings. When the proceedings will end, that is the question here. Now there are many situations here. If the settlement agreement is signed, the termination of proceedings, when the proceedings will end, after this there will be no proceedings. That is the date of agreement. Settlement agreement signed, the date on which the agreement is signed, will be the date for termination. By a written declaration from the conciliator. The conciliator is giving a declaration. From this date, the conciliation proceedings will not happen. Like that, if the declaration is given, it will be from the date of declaration. If the parties give a declaration that we are terminating the conciliation, then the date of declaration will be the date. If there's a declaration from one party, if one party wants to give a declaration, he should give to both conciliator and the other party. One party is giving a declaration. He should give it to both conciliator and also he should give it to other party. If the party is giving declaration, what declaration he is giving? I am terminating the conciliation proceedings. If that declaration is given, the date of declaration will be the termination date. From the date of termination, the proceedings will be ended and there will be no more proceedings for conciliation. This is given under section number 76. Settlement agreement, date of agreement. Declaration from conciliator. Whenever there is a declaration, from the date of declaration, the proceedings will be terminated. Now, we have reached the end of conciliation. Now, we have seen all the sections relating to conciliation which are given in ICAI study material. In the conciliation part, in the Act, it is given from section 61 to 81. But I have covered here all the sections which are given under the study material. You need not refer any other sections. This is a very, very easy chapter. And if you revise it 1 or 2 times, it will be very easy for you. And you can solve the questions very easily. So, all the best for your exams. And see this video one more time if you want to revise this. Before the day before exam, this video will help you very much. Thank you.